petition is dismissed. Dismiss.
Item 2.
Some certain observations I have partly allowed the petition.
Item 3.
The revision petition is allowed.
4.
Yes, this criminal revision is allowed and the proceeding is quashed. In view of the judge. Yes.
Item 5.
The contempt proceeding is dropped and liberty is granted to the petitioner to raise his grievances in some other proceeding.
Item 6.
The petition is dismissed.
Item 7.
The criminal MC is allowed and the impugn order is set aside.
Item 8.
The criminal MC is dismissed.
Item 9.
Sorry. Connected matter, right? Dismiss. Same one.
Item 10.
The petition is allowed and the FIR is quashed.
Look,
Yes.
it's filed on 6/11/24 CRLMC along with the petition for stay. Either maybe listed tomorrow or on Monday. Filed on 6/11
This is the
CRLMC.
if you give, we'll just.
Look, I pray that either tomorrow or 6/7 I will not be there
Okay, 6/7 you are not there.
Not
I'll
there.
adjust.
on Monday.
6/7 Kori the one. He's not there. Okay, Monday. Okay. 10.
It's on tied up bail matter. Your lordship had adjourned it to the 18th.
No, now after that judgment,
So
I,
this is tied up, my lord, because your lordship has rejected the earlier acts.
no, but after that judgment, just recent judgment, there is no tied up consent now. It will go to the assignment. You know that that earlier judgment is they modified that judgment. That's the problem.
CRLMC matter, lordship, quickly that one 21st February. This only last week is very not comfortable. Tomorrow it will be I 7th. Second one, which is maintenance of the second one.
The first one is cost.
First one is dismissed.
Okay.
Thereafter, second one is filed, that has notice was issued. That maintenance is challenge in this CRLMC.
We just see how can we adjust it.
My lord,
We adjust it.
my lord, two CRLMCs arising out of 138 in a case. Well, I am the opposite party. The stay is operating against me. So trial is stalled, my lord. I'll pay
इसको देख के लगा था.
any day, but I pay my lord on Monday, my lord.
Not Monday, we'll see. Next week, somehow.
Yes, ma'am.
Lordship, if the CRLMC 3/3/2024, it was specifically adjourned to 10/2/2024. Lordship has raised the matter from
Within this week, coming week, all the matters will come.
But I don't mention, your lordship, fresh CRLMC applications pending in the investigation is not complete till 2014, your lordship. 10 years is already gone, but investigation is not completed, charges has not been filed. Offense 506.
You want the charge sheet to be filed against you?
No, my lord. I am
You
not.
be
I am
happy.
sorry, Mr. Lord.
Be happy. Nothing is happening.
Passing of the proceeding, I will file. Fresh challenge, sir, case.
Nothing is happening. You should be happy. देख लेगा।
My lord, Belgium matter, man.
Belgium.
This week, sir.
Yes, Mr. Mahanti, you.
Acts of criminal cases, if the lordship remembers, a battery of lawyers who are appearing, including my senior, from the complainant, who is popular of Ashok Parija.
All that big group matter. Investigation is going on.
But the difficulty, well, it was last taken on 15/2, when the order was passed that it will be taken up on 28/2. Remember, the opposite side, the complainant had reached out to us saying that 28 is the difficulty. So they mentioned it on 19 before your lordships. Our understanding was anywhere between 5, 6, and 7 would be preferable. In fact, my lord, on 5th, then our understanding was it will be taken up on 5th, my lord. I don't want to go into the detail of why it was our understanding.
Yes. What do you want now?
Difficulty today is, my lord knows that.
What difficulty? I have protected you. Investigation is going on. What difficulty?
No. The difficulty today is they have already booked the tickets for 5th for hearing. My lord, that is, my lord, my only prayer, my lord, is this. My lord, if it can be taken up on 5th.
See, you don't forget that you are representing big clients. Ticket is not a problem for them.
That is not a problem. The problem is not finding a calendar date. As a lordship knows,
I'll just see how can we
have
get it.
experience in Delhi, my lord, your lordship has.
We can see that.
Finding a date in the calendar. Well, my only
But
prayer was.
yes, it may not be possible because see,
The other case has been fixed on 11th.
let it be on 11th.
Yes, my lord. My only prayer, my lord.
Let it be on 11th.
My only prayer is we can start and it can then not be on 11th.
No, let it be on 11th because see, this week and this week is very, very tough.
Difficult to know.
May I, Royal Lordship,
Yes.
attend? With their
Same matter.
Same matter.
11th it will come.
11th, what has happened is one of the matters had come up on 14.
Hmm.
The matter which has been posted on 11th had also come up on 14. Unfortunately, this has been assigned to a date on 11th. The rest of the matters were assigned to a date on 28.
Now, in any case, all the matter will come on 11th.
May I just frame it?
Yes.
My seniors, Mr. Parja, and all are in a difficulty on 11th. Can it be any time after on 19th?
You sort it out yourself and tell the court master will do. Sort it out yourself and
No, my lord.
I have no problem.
My lord, it was fixed on 28.
I understand it,
Now,
but
19th is like a month away. My lord, my point is. any
you
date of-
sort it out yourself
Can it
and
be
tell
on
the
the
court
7th?
master.
Can it be on the 7th time?
No, not this next week is very tough.
My lord, then let it be
This
on
week.
11th, my lord. Then we will.
11th, I am telling you. If you have any problem, tell you sort it out and tell. Yes.
We can start.
Next. Any,
No, anyways, they have 3 senior lawyers appearing for the complaint. and I'm
see,
sure-
see, I have protected you. Investigation is going on. There is no pressing, urgency now.
Well, that's all we
Therefore,
want is
please
let all
hold
the
on,
matters
huh?
be tagged together because like one matter went.
All
forward.
the matter list you give.
I have already given, I'll
Yes.
give the court master.
And you just sort it out in the lunch time. You tell him that. He will. Okay.
Keep it.
You decide yourself and give,
Madam.
tell the date. It will be it. Yes. Yes. Any mentioning? No. Okay. Page by page.
Can you mention items 11 to 18?
12, my lord.
12. Yes.
A matter where your lordship has protected the petitioner, the age is not, the girl's age is now 17 plus. For that, they have a child, your lordship has protected and given a long date.
Wait. Today I have pronounced a judgment.
Yes, my lord.
I am just adjourning it. Reading.
Item.
Today I one matter that.
I'll see among
That
them.
POXO issue was a big problem because of the judgment up to the Supreme Court judgment.
Yes.
And I have already a judgment, Rosalie.
Yes, sir.
Okay. Previous judgment. Because of that, I was not able to do. Now I try to distinguish that.
Yes.
If you can derive some benefit, definitely do that. I'm just adjourning it.
Let it come.
Okay.
Yes.
Read that judgment. I don't know which judgment out of.
I will see among the.
Amongst one of them.
10.
Huh?
10.
8.
8. I will see.
8. He says 8. Yeah. 8.
Hmm.
Okay.
I will see.
Just see, I'll put it next week.
Your lordship put it next week.
10.
For internal.
Entry more to continue next week.
Yes.
Just go through.
They are giving joint affidavit. They are having a child. They are residing separately.
I think you get benefit of that.
Yes, sir.
Yes.
Next week, any day.
Next week. Yes.
Item 19, my lord.
This item, Anjali,
All the petitioners and active informers are coming here.
Okay, 2 o'clock. 2 o'clock, yes.
20 to 29.
Yes.
30 to 43. 44 to
34, ma'am.
34.
34.
Yes, madam.
My senior is Hon'Ble, my lord. Kindly taken on next week.
Okay, adjourn on request. Okay.
44 to 55. 56 to 68. 69 to 75.
71, madam. Next week.
Okay, on request, huh? Notice issued to opposite party by return undelivered. Endorsement refused. Fresh step you have to take. Fresh step, huh? Notice fresh step. Okay. Yes.
76 to 84.
81 like I don't know any other date as the
81?
81.
Okay, 81 adjourn.
79
Yes.
81 minus Monday. Monday minus.
Not Monday. You are asking for adjournment means we will adjust our this thing. Not
Item 79 minus.
yes.
2 weeks time may be.
Okay.
Minus 2 weeks. Minus interim order to continue.
Entry mode.
Obliged minus.
85 to 90.
79.
I beg your lordship's pardon, my lord. Item number 87. I request your lordship to take up this matter because it's a release of interim release of passport. Your lordship.
Today I think I can take it up because
Yes,
there are
Because
many-
it was specifically adjourned to 21st. And my
Okay,
lord,
I'll take
I'm in deep
I'll take
trouble.
it
my
up.
lord.
Yes.
I may be pardon you.
Yes.
But mention your lordship. NIAC matter. Your lordship was pleased to stay the trial on the ground. He said the counsel for the petition said that he will repay the amount. And on that promise, your lordship stayed it. He has not paid there also. The order unfortunately is not uploaded. So it was adjourned to January 15th. I've tried to get it
Take
listed.
it,
just
take it
not
out,
come.
please next week. Next week.
Obliged.
And was it reflected in the order itself that he paid?
Yes, sir. Reflected that we will try for settlement. 1 lakh be deposited for adjournment. He had initially deposited a lakh or so. Second order, lordship reflected again 1 lakh. Unfortunately, the order was not uploaded. So then he's playing.
The second 1 lakh rupees has not been paid. Yes.
Pardon, my lord, item 17, I will prefer on. 17, my lord, on behalf of Mr. Podira.
17 adjourn. Yes. Chalo. ठीक है.
Item 11.
I'm challenging the order of cognizance. So far as FIR is concerned, not sure have a glance to the FIR. FIR allegation मिला.
Yes.
That is allegation. And what you may see 341, 294, 323, 325, 506, 34 IPs. FIR was registered. What you may turn to injury law.
Charge sheet?
Charge sheet submitted, added 307.
Okay.
Injury law you may see.
Cognizance is taken 307.
Yeah, yes, that is understood.
Yes.
30, then 25 page.
Yes.
Injury. Simple, swelling hochi overhead.
No, but then simple doesn't mean that 307 will not.
You lordship may see. Kothra Magila, history. Lordship may see page 20. That's it.
So why cognizance then?
This is a sad
I know you.
political issue.
I know it may not be made out, but not cognizance.
Can myself take cognizance when FIR has been lodged against the petitioner on the such a
See the again you have to see the intention part.
dispute.
I understand you. Fish bowler car intention of the Maria Paisili fish bowler Mario.
Settled matter than authorized.
Huh?
It is not settled matter. It has not been settled. That is a matter.
I will settle your politics.
I am ready.
I'll just issue notice.
Again, mo bada bhai hele bhi mo sabut mein raji.
I'll issue notice, brothers. Why and
Conciliation settle kar denge.
I'll issue notice. Bring him. Four seated.
এটা নোটিশ যাইছিল হতে
নোটিশ যাইছি
হ্যাঁ যাইছি অলরেডি সি আপিও বি করছেন
দেখো নাই নোটিশ যায়নি देखो तो notice गलत.
नहीं, notice.
Serve through the IO. Serve through the IO.
Yes.
Bring him here. He's brother after all.
Yes.
Now, these,
Unnecessary.
if I,
Feast flow.
it is, petitioner 1, 2, they are serving outside. ତାଙ୍କ ଝିଅକୁ ବି ପକ୍ଷ କରିଦେବେ discharge ହେଇଯାଇଛି.
Family dispute basically. Through IO, I'll serve them.
Yes.
Through IO, sir.
I will serve copy.
Sir,
Course of-
additional copy to be served. And I short date the Babu. Khatam kar. Yes.
Interim order for it.
Entry mode.
Okay.
13.
Give a copy, sir.
My lord, course of it.
Yes.
Ma'am,
Yes. Yes, sir.
the interim release of the vehicle in the forest offense case. Rejected by the ADJ and thereafter allowed by the discharge. I have complied the conditions of release since 31st of October 2023. Vehicle not released. Thereafter filed a petition before the Supreme Court in CRLMP. Then order passed.
Yes.
Then meanwhile, what happens? During pendency of the CRLMP, the confiscation proceedings were disposed of by the authorities. They say that the confiscation proceeding disposed of. Then what is the reason for interim release?
That's the problem. See,
Yes.
it is an interim release.
That
Yes.
in CRLMP,
Hmm.
I say that I have filed appeal. I have challenged the order of the confiscation proceeding in before the discharge, which is appellate authority.
Yes.
In 56(3).
Yes.
Since appeal is a continuation of the original proceeding, so it cannot be said. that the
Okay, I understand it.
confiscation-
What you say that during pendency of the appeal, at least it should be released. That's what you are saying.
Yes.
Because it's a continuation of the original proceeding. That's what. What do you say? There is an order of interim release.
Yes.
And it was not complied with. Meanwhile, a confiscation order was passed. He files the appeal against the confiscation. Appeal is pending. And then therefore he is entitled for interim relief till the appeal is decided.
56.
Huh?
Section 56.
You just forget about 56. You can confiscate, you can do whatever. A confiscation order is passed, no problem.
Yes.
But he has challenged it. What he says is, this is the continuation of the original proceeding. So interim release order which stands in his favor has to be executed.
Yes, I will tell you. I will tell you.
By that time his appeal will be
My case is covered by Kalandi Vera case, you will not be objecting
is-
one case.
what Kalindi Behra, this is a fundamental thing.
Yes.
There is an interim order in his favor.
Yes, yes.
That has to be executed till the finally you confiscation is upheld.
Yes.
Tuesday,
I think, yes, yes.
Tuesday, you come Tuesday and
Yes.
tell, make a statement, let it be released
Yes, yes.
with whatever conditions are there. Shall I allow it?
Tuesday, madam.
Now, what I'll say is the interim release order passed by the shall be complied. Subject to giving an undertaking that it is subjected to the outcome of the appeal.
And he has previously approached this honorable court perhaps.
I am telling that.
Yes,
CRLM
We previously approached, by that time confiscation order was passed.
Fast, madam. So now another petition is not maintained for it.
Don't go over all these things. Why are you, see,
Fast.
you forcing him to come again and again to this court, unnecessary. Tuesday.
Item 40.
Yes.
Ornaments, right? Ornaments. Kind of-
Sorry?
Release of ornaments.
You have to,
Whenever kindly.
you tell the full sentence.
Madam,
When you tell the full
I am the
sentence,
informant.
you are only saying ornament. What ornament?
Well,
This is a
kindly see the page number 32.
32. Okay. Yes.
It also creates doubt that second line.
Who are you?
But I am the informant.
You are ornament, huh?
Ah.
A theft case.
मोठू सब नेले देखि मते नै मते देइछन्ति केवल ब्याग एटा तारि भितर ornaments थिला ornaments देनाति ओन्ली फर ब्याग ता रिलीज कर
31 page ରେ ଲେଖା ହେଇଛି।
You could not give any proof of the owner.
ନାଇଁ ଆମର ସେ କହୁଛନ୍ତି ଯେ 150 ଗ୍ରାମର ନେକଲେସ୍ ଇଏ ହେଇଛି ଆମେ ଦେଖଉଛୁ 69.97
Those things
କିନ୍ତୁ
you have
categorically mentioned in 161 statement କଣ ସବୁ ରହିଛି
not on the basis of 161 statement, the 457 application cannot be decided. Gold will cease from you. You have to show the ownership, invoice or anything of that sort. You read 161 statement and 161 statement of accused or someone else. You show your ownership, as simple as that.
ଆମର ପୁରୁଣା 69 ଆମର ସେଗୁଡା ସବୁ ଆକ୍ସେପ୍ଟ କରୁଛନ୍ତି ସିଜର ଲିଷ୍ଟ କାଇଣ୍ଡଲି ସିଜର ଲିଷ୍ଟ ସେଥିରେ ସବୁ କ୍ୟାଟେଗୋରିକାଲି ମେନସନ କରାହେଇଛି ଆମେ ଆଉ କଣ ଏମିତି ସେ ପୁରୁଣା ଜିନିଷ ଗୁଡା ଯୋଉଗୁଡାକ ଅଛି ସେଗୁଡାକ
What do you say?
ଆମେ କଣ କହିପାରିବୁ
ପୁରୁଣା ଜିନିଷରେ କିଏ ରଖିଥିବ ଇନଭଏସ କଣ କୋଉଠୁ ଆଣିବ
କିନ୍ତୁ ସେମାନେ ଆଡମିଟେଡ ସବୁ କରୁଛନ୍ତି
practical difficulty you just imagine. Who will be preserve it? You purchase a gold, you forget it thereafter. Where you throw it through the invoice. If you ask for an invoice, where family will get it?
He can produce some documents.
Huh?
He can produce some documents.
What document do you expect?
Unless the evidence is there, document evidence there.
You are correct. The court is also correct, but see the difficulty what he is facing. Find out some solution.
Yes.
Some undertaking, some indemnity, something you take and give it to him because it is his this thing. He is the complainant.
Do you have to so that
What
some
security you can give?
any condition ଆମେ interim measure ରେ ନବୁ
That's
Any
right. What
condition?
you will furnish bank guarantee or what? What is the amount involved? The 150 gram.
110 150 gram 150 gram
Very small.
ଆପଣ ଯୋଉଟା
I'll release it. Just forget it. You give indemnity bond and I'll give. 150 grams, na? Na kg.
ନାଇଁ ଆମେ ତ ବକର ଲୋକ ଏତେ
Right. Petitioner is agreed by the order dated. Order dated. Where is the order, sir? Order dated 8/5/2024, whereby the application, her application or his application? Nirupama, her application under section 457 CRPC for interim release of the gold ornament, seized gold ornament, release of gold ornament from gold ornament, that is one gold chain weighing about 12.60 grams, one finger ring weighing about 1.62 grams, 2 earrings weighing about 8.05 grams, 2 numbers of necklace, each weighing 21.39 grams and 16.73 grams, and a finger rings weighing 29 gold. Total 150 grams. The bracket 15 tolas. Has been rejected. Petitioner is you are the informant. You are the informant. Petitioner is the informant in the previous Court CS case number 631 of 2021, registered under section 380 of IPC. 380 of IPC. The trial is going on. The accused has trial is going on.
notice ଯାଇଛି କି କଣ
The accused has been apprehended in this case, and the gold ornament, as mentioned above, has been seized from the accused. Petitioner being the owner and the complainant for the complainant in the case, moved application under 457 CRPC for release of the gold ornament. The trial court, by the impugn order, rejected the application. Rejected the application inter alia, observing as under para 5 P31. Para 5, page 31. पूरा देख लीजिए पूरा page 31. The land counsel for the petitioner submits that the gold ornament to which which were stolen from the house of the petitioner are the old government as a region old government and she doesn't have proper received or invoice to establish the policy. Therefore, it is difficult in her part to produce the documents. Confronting with the practical difficulty the petitioner is facing, he submits that petitioner would furnish adequate undertaking and furnish indemnity bond if the same is released in interim release and shall also give an undertaking to the court that as and when required, the same gold ornament shall be produced before the court. In view of the aforementioned, I am inclined to allow the petition and set aside the order dated so also. And now you move applications, set aside the application and give liberty to the petitioner to move a fresh application before the court below or the such application is moved, the same shall be considered. Yes. Yes.
I've taken up 1 week after.
18.
15, item 15. 1 week after.
No, my lordship. No, my lordship. On behalf of Mr. Senior Counsel, Mr. Agarwal, I kindly seek for Passover and let the matter come after lunch.
Because the case is posted on 20th for charge. So that I prefer after charge I will.
Is there any stay?
No. That's a fresh matter. Purely fresh matter.
My lordship, on last occasion also he took adjournment.
No. If there is no stay, charge is going to be framed.
On 20th.
Let it be. Just see. If there is no stay, then
No. That is fresh matter. Purely fresh matter. Second time SC.
If he is bargaining the risk of getting the petition instruction,
My lordship, let the matter come after lunch.
after
After lunch.
okay, pass over. Yes.
Yes, my lordship.
She's opposing what? She's opposing. I can't help it.
Civil legal senior division.
There is an opposition. I can't help it.
Next week or
That's what she is opposing.
No, my lordship, not next week.
She's
Let the
opposing.
matter
Next.
come after lunch.
16.
I am challenging the order of Dr. 35277 on the
Yes.
section 452 to 94506.
Yes.
Charge sheet to time. There's a direction. Well.
Where is the charge sheet? File the charge sheet.
Course of the
In the petitioner is challenging the order dated 3/5/2017 passed by learned JMFC Council taking cognizance of offences punishable under section so and so. Page 18 order annexure 1, right? However, the petitioner has not placed on record the copy of the charge sheet, seeks an adjournment on that ground. Yes.
I am my knowledge.
First of all, you file a complete petition. Yes. Next. 17, 18.
Here there are two matters before your lordship.
Yes.
My lord, the offense alleged and have been charged.
Two matters means 17, 18.
No, 18.
Awesome.
18, there are two matters before your lordship. One is CRLMC 3956 of 24 and another criminal division is there. My lord, criminal division was filed against the application refusing to discharge. That matter is in the final form. I have been charge sheeted under 341, 294, 506, 34 and section 3(1) Roman 10 of the SC and ST Act.
Yes.
In the meantime, my lord, the parties have settled the dispute. if your lordship may kindly turn to page 42.
42 of who your petition?
My brief, my lord, that is CRLMC 3956 of 2024.
Yes.
There, the complainant filed an affidavit in the court below that the parties have settled the dispute and he doesn't want to
Yes.
any grievance.
Hmm.
The learned court below could not take up the matter. The reason is there is an interim order passed in the revision. That order your lordship may kindly see at page 39.
39 of your first petition.
First petition.
39. Yes. 39. Yes.
Third, private prosecution is directed to assist special people Balasur. No status report has been filed by the accused petitioner. Petition is directed to supply the up-to-date status of IA number 93 of 20, awaiting draft of criminal revision number.
Where is, show me that revision petition.
Revision petition has been filed by my learned friend.
Yes, revision. Where is that order stay? Entry measure. Directed that the proceeding of special case is stayed. Yes, madam. Shall I vacate it and let it be?
Most of the parties are, before your lordship has directed the parties to come up so that your lordship can quash the matter, because now there is no.
What do you say? See, the parties have filed an affidavit before the trial court. We have settled the dispute and all. But the trial court could not take up the matter because in the connected matter, that is the revision, there is a stay. There is a stay. Both the matters are now listed. Parties are here today. So if they are coming, then I'll dispose of both the matters.
Yes, they are in VC most probably. I have instructed them that they should come in VC because from the.
You call them at 12 o'clock. Okay. Call them at 12 o'clock. I'll do it. 12 o'clock or 2 o'clock, whatever.
2 o'clock.
12 o'clock. Let your junior be there. I'll do it. Okay. Both the matters can be disposed of. Yes. You call them and tell. Do you have any objection to that, madam?
I know that.
You have any objection? Both the matter I'll dispose it up. The revision also can be disposed of because of that stay which is operating in the revision petition. The application moved by the
petitioners are same in both the cases.
So now the fact of the matter is parties have settled their dispute.
Right.
They've given affidavit for trial court.
Right.
Trial court can't proceed because there is a stay. Stay. So what I'll do is both the matters I'll tag and dispose of by one order. Both the matters. Let them come. Let the party be here. You just ask them at 12 o'clock.
My lord, one thing subject to correction. Your lordship may vacate the interim order and remit the matter. The learned trial court, they will appear before the court. But there will be another problem. The learned trial court cannot
quash it.
Yes.
That's the problem. I know that. That's the reason I told you.
That is the problem.
Yes. I would have vacated and remanded.
My lord, can it be taken up on Monday, subject to your lordship, so that I will ask them to come in personal? Lordship. Physically Monday if they come.
Okay, Monday.
So that in your lordship's presence, the matter can.
Yes. Monday.
20.
Cognizance, in the meantime, some persons, including the husband of the deceased, they faced the trial and they were acquitted. Absolutely no material to proceed against bail petition.
498A.
2 years. Madam, we turn to the judgment at page 18 onwards.
This is which is the judgment.
The husband, father-in-law, and mother-in-law. All of them.
No. The
benefits of the brother-in-law, elder brother-in-law.
I understand who is acquitted. Husband is acquitted.
Husband, father-in-law, and mother-in-law.
No. Come to page 14.
18. And we'll see 18. 1. Number one, who has paid the trial is
18.
Robbie. Is the husband. The other two.
1 minute. This is item 19, na?
20.
20. Okay. 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 Sorry. Yes. 18, huh? Yes. Yes. Rabbi, Sibo Naik, and Surekha. Surekha Naik. All of them are acquitted by the judgment dated 2000.
Yes.
2000. Now you are the brother-in-law.
24/11 to 30.
How many accused were there?
Oh, my lord, 4%.
4%. 3 of them are acquitted. One of them remained. Who are you?
So, the elder brother-in-law, the elder son.
Where were you? 2000, today 2024. After 24 years you are coming.
Evidence is contrary to
No, evidence, everything is all right. Wherever you, 2000, these people were acquitted. After 24 years you are coming.
that. Surat for the.
You, huh?
Surat.
Though there is no limitation and understanding for it to CRPC also.
That-
90 out of taking cognizance.
No, that's
Present prison in absconder 1. That is the whole difficulty.
but what will you do after 24 years? Will you convict him?
I'm not saying also, but the facts remain, and one more commission also, the present person earlier approached for the honorable court, 438 CRPC for bail. This coordinate his bench is some direction about it.
But try to be very practical. In these kind of
I'm
cases,
not-
24 years back, 498A, husband, mother-in-law, everybody is acquitted. Brother-in-law was working there in Surat.
But here is the 98 order of cognizance and absconder.
Burdening the system, nothing else. Burdening the system.
And the copy and flag is affidavit.
Have you surrendered? There is order, you what to do? You first comply this order, then you come. You try somewhere else. The coordinate bench passed some order. Today, to subvert that order, you are coming here. You comply this order, then I'll quash it. Whatever you have invited this order. Comply that order and come. I'll quash it. That is, you have invited that order. Otherwise, this is a matter for quashing. You got an order from a coordinate bench. You don't comply and straight away come and asking for quashing. You comply that order.
This part is concerned with my story.
I can't subvert this some order passed by the coordinate. You comply, just simply adjourn it. You comply and come.
My lord may add some line in particular case.
I will not say anything because it's a case for quashing according to me. 24 years back, all the in-laws, husband, everybody is acquitted. You are the brother-in-law. You have been absconding for 24 years. That's all.
Case that is issued in the year 1994.
94. Nothing is there. You can't pardon the system. But the only problem is he has invited this order. Has to be complied. You comply and come. Do it. I'll put it next on 13th. I'll quash it. Oh, 13th. 2 दिन रहियो 3 दिन रहियो पळै आसे क्वाश करदा कोन आपण इनवाइट करथनि मु कोन आई कांट डू इट हां surrender and same day because
that is so bad. Keep it to Friday. I will try to surrender on Thursday. Whatever the result may be, I will get a copy and then he surrender.
And then not Friday. The next week you talk about next week. That is why I am saying 13th.
I will fix any day.
13th. I am fixing it. 1/13. You do it. You comply it immediately. Yes.
21. You are my lord.
Today, tomorrow you comply and finish it up.
The lawyer can say, happens in front of you.
Whatever you.
Because you definitely not get it on by the court below.
You know better what to do. Yes.
21 minor similar matters Lordship has fixed on 26 March 25. There are 12 cases. Here, petition under 143A for grant of interim compensation under NI Act has been rejected. 12 cases are there.
Want this matter to be listed along with that? Please. Yes. Yes.
22. Oh my God. Function and gravity of application, I want to withdraw the application and there is also my.
Sorry?
But the application is liberty to raise all the parts and.
Okay. Liberty, withdraw and liberty. Yes. Yes. 23. Pass over.
24.
Initially, one of the affair was law under section 394.
Yes.
Section 31S and 32BA of the SCST Constitution.
Yes.
The investigation was done and charge sheet was submitted only under section 294.
Yes.
But the learned magistrate, the learned court bill special judge, he has taken cognizance of the offense under section 294 as well as the SCST.
Yes.
Stating there, the order lordship may kindly have a glance.
Yes. Page 20.
Page 20 starts the relevant portion matter, page 21.
Yes.
In the instant case, the FIR was lodged against the accused for the offence under section 294, reduced section 31S, 32B of the SCST Act, and prima facie there appears sufficient material to proceed against the accused under the aforesaid section of law. In my opinion,
Before that, go to a previous page.
Yes.
Page 20 at this juncture.
Yes, sir.
Read it.
But at this juncture, on perusal of FIR 161 CRPC statement of the witnesses and the cast particular of the victim and accused, prima facie discloses that on the date of occurrence, the accused, who not being a member of SC and ST community, had abused the informant by aspersing his caste name. That is not there as per the investigation.
Investigation may not be there. 161 statement. Show me the 161 statement. Charge sheet, in the charge sheet, police might have said whatever.
That is not there.
But in the 161 statement,
mark for the last part. The witness statement. Last part just can mark. जैसे जाति को आक्षेप दे गाली देवार आमे सुनना गाली देवाटा सुनी तो लेकिन जाति को आक्षेप कर गाली देवाटा सुनना On this, the IO has submitted charge sheet under section 290.
this is one statement. Yes, what do you say? Where the trial court is relying upon 161 statement.
Yes,
and I don't know how many 161 statement.
Let it come next week, Your Lordship. In the meantime, call for the case.
Because all the 161 statement, what we showing, apart from that, if anything is there, I don't know.
Certificate copy I have given. All the
No, how many witnesses have been examined? I don't know.
that is there, man.
But you have not filed. You could have verified it. All of them at the end, they say, Caligula Jaichi. So and so, कौन इसको बनाया and all these things. But जाति को आक्षेप करके गाली देवा हमें सुनी ना हो. Everyone is saying, if that is the case, where is the HST?
Let me solve the statement, Your Lordship, and verify.
And the trial court is taking cognizance only on the basis of the 161 statement. That part has to go.
So let it be come next week, Your Lordship. In the meantime, call for the CD and after
Why you are not placing it?
That I have got it.
Yes, issue notice. Yes.
Petitioner is lady man.
Lady, then
Employed under MCL.
employed.
Yes. There is a dispute between the management
Right.
and the.
Okay, I'll stay. Right. The petitioner is
He was
the
getting
accused.
compensation of
Petitioner.
brother
Petitioner.
who died.
Wait, petitioner is the accused. And in the FIR, anybody has said anything?
FIR was given by the informant. He has stated.
But in the FIR, she has said.
Yes, yes. That's why 3 years.
इसको कोई नहीं कुछ नहीं आता है
हाँ.
by expressing his caste. This much is there in the FIR. But in 161 statement, nothing is there.
Okay. Public place नहीं है तो independent witness man तो कोई बात नहीं क्या कोई ना.
Okay. Petitioner is going to be accused in FIR number 2. Allegation against the petitioner. After investigation, charge sheet in the present case has been filed by the police on 31/10/2023 for alleged commission of offence under section 294 IPC. The investigating agency, by relying upon the statement of the witnesses and other materials, arrived at a conclusion that there is no offence under the HCSP is made of. Prevention of HCSP is made of. However, the trial court, by the imbue order dated 17/11/2023, has taken cognizance of offence punishable under section 294 IPC, as well as for the offence punishable under section 3(1)(s) and 3(2) VA of ST/ST (PA) Act. The trial court inter alia recorded as under while taking cognizance at this juncture. Mr. Mishra, that counsel for the petitioner has to take hands up for the private copy of the 161 statement of the witnesses. All the witnesses have very categorically stated that none of them have heard the petitioner abusing the accused, the accused abusing the informant by expressing the his or her caste. Therefore, the observation made by the trial court in the imbue order is contrary to record. Contrary to Mr. Mishra, on the basis of the aforementioned, submits that no offence under the provisions of SC/ST PA Act is made out against the petitioner. Issue notice, Mr. Manke accept notice, written so and so. In the meantime, proceeding before so and so state. Yes.
25.
And in this case, the accused and the complainant all are belongs to the Lord Sebayat Milord, Lord Jagannath Milord, Temple Milord. During the period of the Gundicha Jatra, the dispute arose Milord, and later on has been compromised Milord. Offenses 290.
What are the offenses?
Minor offenses 341, 323, 506, 294.
Bring them.
My lord.
What time?
Let's see, 1 week of time.
What 1 week? Bring them. There. Let it be on 7th.
Next week.
Next week, okay.
11th, after Dolo Jatra, because there are busy in the.
When you tell me 11th, 12th, when?
After Dolo Milord, any date Milord.
18th. 18th. Okay. Issue notice.
18th. And charge में रही चाहिए
323 440. Yes.
26.
Pass over.
27.
Yes, sir.
The petitioner as the statutory authorities, this applicant challenge the acquittal order passed in 2CC case passed by the land SCJM Special Court from SCJ Cuttack in favor of the opposite party without following the due and proper procedure of law as per the provision enacted under the Income Tax Act. Just the brief of the fact and but the opposite party is the managing director of the company, namely Mason's Perfect VIP Techno Solution, and has deducted a tax at source amount.
What is the tax component involved? 15 lakhs.
15 lakhs 25,250 from the salary during the assessment year 2013-14, but did not deposit money.
Even after money without after the time frame also he has not done.
Yeah,
Then there is no question of settling money compounding also.
Minor.
Will he pay or not? Let us see. Has he offered? Has he offered to pay? Has he offered to pay? 3 months.
Yes, 3 months, minor.
After
No,
3 months he paid.
Yeah.
That's what I'm saying. After 3 months he
Yes,
paid.
yes.
What is the compounding amount you have kept? Compounding cost?
That is
1.5 per month.
Compounding.
Yeah.
File issue notice.
Right.
Let him come. Ultimately, he has to pay the money. That's all. Ultimately, yes. What is the sentence? Acha, executed. Okay. Okay. Issue notice. Notice to.
My discharge application has been rejected
Yes.
under the next 5 page.
Page 5.
Page 35. Annex
35. Okay. Yes.
Your question is, let Betra by caste. Informant is Betra by caste. You will also have a glance to Annex 6. I have furnished the ROR copy.
Betra.
Betra.
Okay.
And you will also kindly see next page. I obtained the Information Act from the Tahsildar Satyavali. Next page.
Next page means your.
Page 39.
Okay. Yes.
Betra is not coming under the category of SC, ST, OBC and SCBC. And next annex that SC, ST
Where
order.
is that inviting reference to remove informing that because Betra is
Yes.
not coming under the category of SC, ST, OBC, SCBC. Yes, Mr. Vishwar.
Yes.
Let them
What-
obtain instruction there. This is the
What
only
happened,
point.
the impugned order dated 30 September 2024. And my long friend obtained that RTI information.
17.
Yes.
21/10/2017.
Order.
Your own officer, that is Tahsildar Gi, says that Betra is not
Coming
either
under.
SC, ST, OBC, ACBC, nothing.
Yes.
No, schedule caste order also have furnished Annex 6.
Then why should you? Okay. Issue notice. Write down. No. Then you are agreed by that part of the order only.
3 SCs will go.
Only 3 SCs. Right down. Petitioner the petitioner is agreed by the order dated. Order dated. Better see, instead of I stay the entire proceedings.
Yes.
Better for you is to concede. At least in the for other
No, no,
offenses.
other offense, yes.
Otherwise, I'll stay and it will be pending for five cheeks.
For other offenses.
Let him go and you
Yes.
should concede to that
Yes.
instead of unnecessary contesting.
Yes.
And I have to stay because your own document says that I have to stay. That's the whole difficulty.
Yes.
Yes. Petition is agreed by the order dated petition on the Chabuchi, passed by the 3rd additional sessions Judge Puri in TR case number 13/41 of 2024-2021, whereby the application moved by the petitioner for discharge has been rejected. Mr. Pradhan, learned counsel for the petitioner, taking me to the RTI information and ROR placed at Annexure 6 of the petition submits that the Tahsildar has categorically Tahsildar had issued a certification that Betra, BETRA, Betra is not coming under the category of SC, ST, OBC or ACBC as per the least published wide letter dated letter number 7799/L dated 7/6/2003 of Law Department of Orissa. On the basis of the document annexed to the petition, Mr. Vishnu Pradhan, the counsel for the petitioner, submits that at least the offence under the provisions of AC/SC bracket PA Act is not made out against the petition, not made out against the petition. Issue notice, Mr. Vishwal accept notice, returnable also to file a response to the same. In the meantime, proceeding before so is stayed. Yes.
29.
Disposed of.
No, I have said the proceeding. He has to tell. That's what I was suggesting. You come and concede so that at least he can face other offences.
SC/ST order ta verify kardele heijib.
Good week only that just see the law department letter already is referring to.
Yes.
Just see if it is there. You can't change the status. You can't change the status. Yes. 2 is for the
Petitioner files his application challenging the order of a cognizance matter.
Yes.
Kindly peruse Annex 3, my lord. One accident was occurred and the petitioner.
1 minute, Mr. Vishnu Pradhan. Shall I dispose it up? Because this is no. The trial court has not considered this aspect. Not at all considered this aspect.
Yes, that impugned order, sir.
And I'll set aside the impugned order and send it back to the trial court.
Again, court below.
No, but by relying upon this, he has to take a call. That's a better idea because everything will be there, black and white. Yes. Set aside the impugned order and by relying upon this, and send it. Okay. Yes.
Yes, my lord. Kindly peruse item Annex 3, my lord, page 40.
That 29.
29, my lord.
Sorry. Yes.
One accident occurred and the petitioner as IO investigated the matter and submitted a charge sheet, my lord. Arrested the driver of the offending motorcycle and submitted charge sheet. Thereafter, on FIR registered by SP Dhenkanal, re-investigated the matter and entangled the petitioner as accused, my lord.
Yes.
The petitioner only discharging his duty as a government official without sanctioning from authority. The learned trial court has taken cognizance against the petitioner.
Yes. What is wrong in it? The facts are correct.
Yes, my lord.
But what is wrong in it? You have to tell me.
Sanction not obtained.
See, how will you say that it is during the your official function?
Official capacity in the sense, my lord, he was IO in that case, and inquired the matter and submitted.
Let us see. What is your name? Name is Prasanth Kumar Lenka.
Yes, my lord.
Let us see the charge sheet.
Yes,
what are
page 37.
37.
It is established.
Yes, read it out. 37.
It is established that no such accident ever occurred on so-and-so date by rider Prahalad Nath. Rather, the medical report suggests that the injured Tatkar Parida sustained injury due to fall from tree. In order to get pecuniary monetary gain by way of filing MASCA case, advocate so-and-so injured Dr. Parida, owner of the motorcycle Pradeep Kumar Sahu, rider Prahalad, and thereby could able to register RTA case, right so-and-so. The IO of the Parjang PS case number so-and-so, Prasad Kumar Lekar. Now the petitioner, without proper investigation and verification of the claim, filed charge sheet in the court based on which MSC case was.
This is your.
Jaha Koili, yes, 7 sir investigated. As per their statement, he has submitted charge sheet.
All these things are fraud.
Yes.
Only to obtain motor vehicle exchange claim.
They have
wrong cases are registered.
They have committed a fraud. The victim, driver.
Why for you are there? You are supposed to investigate properly.
Yes, madam. Yes, madam.
And you are also a party to that.
And yes, 4,12,000 some odd has been awarded in favor of.
MHCT cases are filed.
The injury person and the advocate, so and so, they are semane nechandi. But the present petitioner, the present petitioner.
Why? Then you are the person who are supposed to investigate and implicate them for filing wrong case.
He has
You
gone,
become a party to that.
he had gone to the spot and visited the spot, taken a statement of the witnesses and submitted that.
Not
He
so
has,
easy.
he has no role, man. तार किसी nexus नहीं जो ये है.
Petitioner is seeking quashing of the order dated 15/5/2024.
Opposite by two notice ta jao, stay no notice ta jao, khel notice.
No. These are very, there is a PIL pending in Supreme Court.
Yes, my lord.
And from this High Court also,
As per
informations are sought
as per
from this
allegation,
High Court.
and racket is there, but racket यार किसी nexus नहीं है तो retired है sir. यार किसी he has no role, my lord.
I was appearing in that matter in Supreme Court. I know what is happening in this state also. Same instances. And the group lawyers, police officer, and everything is mixed up. False cases are registered. Claim petitions are filed.
In order to gain the
money is taken from insurance company. This is what is happening. This is right.
For it to withdraw, my lord. For it to withdraw.
See, he wants to withdraw to raise all the points before the trial court. Yes.
Pardon to my lord. I am in BC, my lord. Item
Yes.
30, my lord.
Yes.
Here the petitioner are challenging the Cognizance order dated 30/11/2023, my lord.
Yes.
And the order is at page number 21, my lord. Here the 1cc case has been come out of a protest petition, my lord. The FIR has been lost on 11/1/2023, my lord. After that, the complainant has filed a protest petition, my lord, in
Yes.
which the London court below has took up the cognizance on dated 30/11/2023 against these petitioners, my lord. And kindly glance up the, my lord, the running page 29, the final report, my lord.
29, yes.
Yes.
Okay, final report. Just forget about final report. Now just see the protest petition. What are the allegations against you?
My lord, the allegation is that, my lord.
Yes.
My lord, allegation is that, my lord, these present petitioners are blocking the passage of this, my lord, complainant, and for in which they are the one Lakshmikant Das using vulgar language to withdraw their previous dispute case, my lord. And however, on 1999, my lord, one of his nephew has been kidnapped by these petitioners, my lord. It has been falsely, my lord, alleged, my lord. That much allegation is there, my lord. Nothing there, and already the final report has been taken false, my lord. Without, my lord, without any inquiry under section 202 of CRPC and investigation on 162, they have the London court below should have balanced the my lord. But in spite of that, they are not balancing and took up the cognizance, simply adding the offenses under section 109 and 323, my lord.
Where is the impugn order?
Page 21.
My lord, at page number 21, my lord.
(202) statement.
My lord, 202 statement. Is that, my lord, page number 11, my lord. Initial statement of the complainant.
That's the complaint. I have seen that.
My lord.
Complaint I have seen. Where are the statement? A statement of The evidence is there, how to get out of it.
My lord, notice may kindly be issued, my lord.
No, notice is not formal notice. Just see, the complaint is very specific. Thereafter, the statement is also very specifically made against all of you. Cognizance is rightly taken. Cognizance is rightly.
Really, my lord, but my lord, it is against one Lakshmikant Das, not with these petitioners, my lord. These 5 petitioners have no allegations against them, my lord.
All these
Simply
petitions, all the
people-
accused persons.
My lord, they have, due to some previous dispute, they have, for the passage
Right,
of
those
road,
things-
the dispute has
see,
been,
those
my lord, has been
those
drawn up.
things are your defense. Those things are your defense. You argue all these things before the trial court at the stage of framing up.
My lord, kindly taking up some short adjournment, my lord and senior will appear in this case, my lord.
Why have you tried then?
Lord, I have tried. This is then my chance, my on my lord and seniors.
Mr. Vishal, offenses are very minor. I'll issue notice for us. Yeah? I'll simply issue notice because the offenses are very minor. So,
My lord, till then, my IA is there, my lord.
first of all, you are seeking adjournment. I am trying to help you out by issuing
Lord,
notice.
IA is
No
there, my
question of
lord.
stay. No question of stay. The order is perfectly correct. But the offenses are minor. Let us, I am issuing notice. Let them come. We'll see if
Well,
settlement
till
can be
then, my
done.
lord, till then, my lord, stay, my lord.
Next.
My lord, till then, stay, my lord.
Only issue notice. Yes. Yes. Next. Okay. Requested. Yes.
32.
May I please, Your Lordship?
Yes, sir.
A malicious proceeding has been initiated against the union leader of MCL. I have annexed the FIR, my lord. How a malicious proceeding, it can be visible from the FIR, my lord.
What are you seeking? Quashing of FIR?
Quashing of FIR and continuance of the proceeding. Till today, case is pending. Your Lordship, may
Continuation of what proceeding?
My lord.
Any proceeding has already been initiated.
Against me, my lord.
Charge sheet,
Charge sheet has been submitted, but unfortunately, I could not be able to place because
That's
Lordship,
what I am wondering. Except FIR, you have not filed anything.
for that is
You are making long prayer.
next week, I file. I have got that.
You file, better you file all this. Right now. Mr. Das, learned counsel for the petitioner seeks an adjournment to place on record. Additional document is substantiating. Yes, leaves the matter after the. Yes.
Next week, any day.
Can give. Yes. File this document, otherwise, how can you?
I have got that certificate with itself.
Why don't you train your juniors to file?
I have.
You must train your junior that all necessary documents to be filed.
To be done.
No, don't file so casually. Yes.
33.
May it please your lordship.
Yes, got any judgment?
My lord, I have got judgments. However, the judgment that I had submitted before lordship earlier, that is the best I could get to the closest to my case, my lord. However, I have got some judgments, my lord. My lord, the first judgment is of Sarojben Ashwinkar Saha under Das versus State of Gujarat.
Yeah. Which paragraph?
Paragraph 16, my lord.
1-6?
1-6.
Para.
My lord.
1-6, okay.
The principles were called out after referring to a catenary of Supreme Court judgments, my lord.
Yes.
My lord. And the relevant point is point number 5, the fifth principle of say paragraph 16, fifth principle.
Yes, fifth principle. Yes.
My lord. The power conferred upon the court is although discretionary, but it is to be exercised it is not to be exercised in a routine manner. In a sense, it is an extraordinary power which should be used very sparingly and only if evidence has come on record which sufficiently establishes that the other person has committed an offense. A mere doubt about involvement of the other person on the basis of the evidence laid in before the court is not enough. The court must also be satisfied that circumstances justify and warrant that other persons be tried with the already arraigned accused.
Yes.
The court, next point, my lord. The court, while exercising its power under section 319 of the code, must keep in view full conspectus of the case, including the stage at which the trial has proceeded already and the quantum of evidence collected till then. Regard must be had by the court to the constraints imposed in section 319(4) that proceedings in respect of newly added persons shall be commenced afresh from the beginning of the trial.
Okay. Yes.
My lord.
Next.
This case refer, next, my lord. The
Kailas.
file.
Yes.
Paragraph 9, my lord, where the section has been reproduced, and after that the consideration, my lord. Para 9, last paragraph. A glance at these provisions would suggest that during the trial, it has to appear from the evidence that a person not being an accused has committed any offense for which such person could be tried together with the accused who are being tried. The key words in this section are: it appears from the evidence any person has committed any offense. It is not therefore that merely because some witnesses have mentioned the name of such person or that there is some material against that person.
But in your case, the problem is in your case, in the FIR, you are named.
I have been named, my lord.
Not that in the, out of blue, somebody has taken your name.
My lord.
Your name was there in the FIR. Charge sheet, you have been dropped. And the witnesses have reiterated your name in the evidence.
In all these cases that I have given, my lord, in all these cases, the name was there in the FIR, not charge sheeted. After that, during trial, the name was taken. Now, the court was of the view that while considering an application under section 319, all the materials before the court has to be considered by the court. In fact, that includes considering the examination in chief as well as the cross-examination, my lord. In this case, the offense is under SC/ST Act, and that is under 3 SC/ST Act. Here, under 3 SC Act, the offense has to be committed in front of a public, my lord. The place has to be in a public view, my lord. In this case, none of the independent witnesses have stated that in fact, the witness have stated that after the occurrence, the Biswajit Bastia, the main accused, has not even said any aspersion to the family of the deceased. In fact, the family of the injured has come to the spot after the occurrence, my lord. So, in fact, they are not even eyewitnesses, my lord. In their depositions, their cross-examinations, there are several discrepancies. The injured says that the occurrence went on for 15 minutes. The wife says that the occurrence went for 8 minutes. Then there are discrepancies, my lord. The wife says that only Biswajit Bastia tore my sari, and that was not there in the 161. The injured says that all the accused persons tore the sari. The only was, my lord. The specific allegation, however, is against Biswajit Bastia that he gave a fist blow on the face of the injured. And also the wife says that none of us went to the hospital, only the injured went to the hospital. However, there is no injury.
Next. Lal Suraj.
Lal Suraj, my lord.
Which para?
Para 15, my lord. The approach of the learned session judge was wholly incorrect. The principle of strong suspicion may be a criterion at the stage of framing of charge as well as matters brought during investigation were required to be taken into consideration. But for the purpose of summoning a person who did not figure as accused, a different legal principle is required to be applied. A court framing a charge would have...
Did not figure as an accused here. He says did not figure an accused, but you were figuring as an accused in FIR.
Did not figure as accused after the filing of charge sheet. A different legal principle is required to be applied. A court framing a charge would have before it all the materials on record which are required to be proved by the prosecution. In a case where, however, the court exercises its jurisdiction under section 319 of the code, the power has to be exercised on the basis of the fresh evidence brought before the court. There lies a fine but clear distinction, my lord.
No, this portion may help you. Court says the basis of the evidence brought fresh evidence. On the basis of fresh evidence. On the basis of fresh evidence. That means if somebody is not taken your name in 161 statement, and on that basis the charge sheet you have been exonerated, and the same set of witnesses goes to the court and make the statement, that those statements are not to be treated as a fresh evidence.
So, my lord, in 319 as at a stage after the trial has commenced, my lord. So, at 319, there has to be some evidence that has the fresh evidence that has come before the court. Therefore, the court is considering an application on 319, my lord. So, now, my lord, whether that evidence, the degree that is to be applied by a court while considering that evidence is not that is at the stage of framing of charge, because at the stage of framing of charge, only a strong suspicion is sufficient, my lord. A prima facie case. Here, it is not a case where the only prima facie. If we consider the deposition of the those PWs, there has been discrepancy as to the role, my lord. One says that all accused persons ke, other says that only Biswajit Bastia ke. Now, whether those discrepancies...
No, all the three witnesses have taken the name of you, that Biswajit Bastia, Your name as well as the name of the other.
Well,
What is
the-
it?
the-
Two of you.
They all have said that they have come together.
Specifically, they taken name.
Well, they all have said that they have come together, but your lordship may consider PW4, my lord. PW4 says that only Biswajit was there. That after that, he says that all other accused persons. Then an omnibus allegation. Now at the stage of 319, the test that is, but at the stage when already 7 witnesses have been examined out of the 9 charge sheet witnesses, only IO remains, my lord. Only IO remains. Now, if IO will be cross-examined as to whether they have stated such and such in 116, whether they have such and such depositions, whether they are contradictory or not. At the stage of 319, my lord, the question remains is what is the test to be applied here? Because this person was not charge sheeted, my lord. Because the investigation is clear, my lord. In fact, these persons have improvised on their statements, my lord. That also there is a judgment, my lord, on one explanation to section 162, my lord. It will be omission, my lord. That will be contradictory, my lord. Because in 162, in the 161.
Okay, you file an exhaustive written note. I'll write this.
Fine.
Okay,
Fine.
and with the reproduce the paragraph which you have pointed
Fine.
out, and the contradiction which you have,
Fine.
and it should be an exhaustive one.
Fine.
Okay. It should be an exhaustive one, and the result of the case would depend upon the manner in which you draft your written note.
May I pray,
You have done a good job, and please do it further. Yes.
I have a decision regarding maintainability of.
You also give a written note.
Yes.
Because he has leveled a hard and got
Yes,
some judgment touching to the point.
My judgment may be taken.
You put it in writing. Put it in writing.
Yes.
Along with the judgment, you give back the judgment. And annex the judgment and give.
Yes.
With exhaustive note. Okay. Okay.
Oh, blessed.
Well done. Yes.
35.
Yes. Yes, sir.
My friends.
That compromise matter.
Yes.
One person could not be present before this honorable court because of his illness. So, lordship may keep it some other dates to produce all the classified persons, or your lordship may send it to mediation, so that the result will report.
Sir, he is the person who has to agree. I have no issue. I will
Yes.
send it to
Yes,
mediation. Shall I send it to mediation?
Mediation along with another CMP is there between themselves, between the parties. Hey, সেটা গলে একাত্তরে হইব।
CMP is not with me.
No, not your lordship, but on our prayer, your lordship can send it.
No, I can't touch that file.
What is this to?
I'll send it. You tell that CMP code.
Yes.
But you tell that CMP code that.
Yes, that may be mentioned so that it will be
yes.
easier for us. CMP number take it.
Right. Petitioner, notice was issued, and the council setting for both the parties. Conjointly agrees that there is a scope of out of court settlement in the present. Therefore, they pray that the matter may be referred to mediation center. High Court Mediation Center?
My lord.
High Court Mediation Center.
High Court mediation. High Court mediation.
High Court mediation. The matter is the matter is referred to mediation, exploring the possibility of settlement. The coordinator of mediation center is directed to fix a particular date. Shall I fix a date in before?
My lord, yes.
Which date you tell me? You'll appear.
Last week of March.
No, don't delay it.
Yes.
Don't delay it. Do it immediately.
On 19th or 20th.
No, you appear.
26.
Sir, you appear on Monday, Tuesday, and thereafter he will fix another date.
Yes, yes, yes.
Monday, Tuesday appear. 10th. The parties are directed to appear before the mediation center on 10th of at 4 o'clock. 10th of March, 4 o'clock, and the coordinator shall fix for the date for the purpose of exploring the possibility of settlement. possibility of settlement.
Your Lordship mentioned about the CMP, if they prayer, they make a prayer, that should be.
Already I've given the number. Actually, number.
Between the parties, another proceeding, namely CMP number so and so,
CMP.
is also pending. The parties may apprise the concerned court regarding the mediation process, and seek for appropriate order.
Interim order to continue.
Interim order to continue. Yes. Yes.
36.
Lordship, for item 36, I'm seeking for an adjournment on behalf of learned senior P. Kirath. He's unwell.
Adjourn. On request. On
37.
request.
The Lordship, on behalf of Mamonan Saktipal, the present criminal miscase has been filed challenging the order passed by the Honorable Family Court, wherein the petitioner is directed to pay 5,000 as an interim maintenance. Again, and the OP number 2, who is the wife of petitioner, has filed a DV case against the petitioner, which was also allowed, and the petitioner was directed to pay 5,000 rupees as maintenance. Now, it's a financial constraint on the petitioner to pay the amount both in the DV case and also in the
Not
CP case.
necessarily, you have to pay only one maintenance is to be paid in one case.
And your Lordship, in that regard, I have filed an interim application to stay the operation of the order passed by the family court, wherein the petitioner is directed.
No, only 5,000 rupees you have to pay. You pay.
But yes, your Lordship, I have to pay 5,000 rupees. But in both the order passed by
That court says that notwithstanding the fact that the other court has passed the order for 5,000, you have to pay in addition. Does it say that?
Yes, your Lordship.
Show me.
Sir?
Show me that.
No.
In addition to the 5,000 rupees which has already been awarded by the 125 court, the DV court maintenance has also to be paid.
That's annexure.
Yes.
That's annexure 2, your Lordship.
Yes.
Annexure 2. Copy of the order passed by the family court.
Yes.
2010-2023.
Yes.
Page 16 is the order.
Litigation directed to pay 5,000 rupees.
As interim application,
Yes.
interim.
Yes. Where is that? This is in the
Family proceeding before family court.
proceeding before family court and section 24 maybe.
Yes, your Lordship.
Yes, section 24. Where is the DV court order?
That's annexure 1, your Lordship. Page 11, order passed by the DV court.
Yes. This order is passed on 22/8/2023, and the earlier order was August. Why have you not informed the family court that there is already an order? I just simply issue notice, let us sort it out. Yes. Issue notice. Sort it out. Issue notice, sort it out. Yes. Yes.
38.
May I please, your Lordship. I have filed this serial MC challenging the order dated, order under annexure 8 dated 25/10/2024, my lord.
Annexure 8, huh?
Yes, my lord.
Yes.
Annexure 8.
Yes,
8
sir.
is the learned turn to
98.
yes, ma'am.
Yes.
98.
Cognizance taken.
Cognizance has been taken by this learned STJ Barampur. Basic upon the allegation in the complaint case is that
that the petitioner, who is petitioner number 1 and petitioner number 2, has sold some petitioner number 2 sold some property to petitioner number 1 in the year 2013 and 14, and basing upon the registered sale deed, petitioner applied for mutation, and the property has been mutated in the name of the present petitioner. They have taken away my property, my lord. And after ROR has been published in my name, I have converted. After ROR has been published in my name, I have converted the land and sold it to 8 persons.
Yes, sir. What do you say?
I have given the complaint.
Notice has to be issued.
Because it's simply a civil dispute.
Civil dispute.
Clear civil dispute.
Yes, madam.
Arm twisting.
Madam.
Issue notice. Shall I send it to mediation?
Mediation, man, lots of people are there. Mediation, if it.
No, I'll send it to Barampur Ganjam mediation. You try, because see, these are purely land disputes.
Land disputes, my lord.
Some sale, some purchase and all.
And challenging the civil, the writ petition is pending. The writ court has stayed the order of the sub-collector, so also by the civil judge, my lord. Here.
Where is that order?
Order is, my lord. I have stated, but order is there, my lord.
Show me that order.
Please.
Petition.
Petition. He also about that. I have annexed the complaint, my lord, which is at page number annexure. Annexure 7.
Yes.
7 as page 82 starts from page 82. He also says that all these things.
You are challenging the cognizance.
Yes, man. I am challenging the cognizance as because the matter is purely civil in nature. The law. Yes,
present petition is seeking quashing of the imbue order 25/10/2024 passed by SCGM Barampur Ganjam in the ICC case number 455 of 23, whereby cognizance of offences punishable under section 338/336 (3 (340) 2 318 4 61 351 2 of BNS has been taken against the petition. The sections are now so confusing. You have to refer everything every time to
referring to old act and new.
Yes. Against the petitioner. The perusal of the complaint petition reveals that the dispute is essentially arising out of the sale of a piece of land, sale of piece of land. There are litigation, counter litigation pending between the parties in the arising out of a mutation proceeding,
civil suit,
and
so also
the civil suit. Regarding head to the nature of dispute, I am of the considered view that the parties should be relegated to mediation center for exploring a possibility of settlement. Hence, the present matter may be referred to district mediation center.
The government officer are party, Tahsildar and Sovereign.
It's all right. Therefore, that is the reason I am saying. That's the reason. Unnecessary, the government officers are. I'll issue notice.
Waive, my lord, kindly for the time being.
I'll just tell you.
My lord.
For exploring a possibility of settlement. The opposite party number 2, complainant. Who is the opposite complainant?
Complainant is, my lord, opposite party number 2.
Opposite party number 2, the complainant has arrayed arraigned the government official as an accused, namely the opposite party.
4 and 5.
4 and 5. And during the mediation process, the respondent, the opposite party number 4 and 5 may not participate. Participate as because the dispute is interest petitioner and the complainant. Petitioner accused and the complainant. Awaiting mediation report, please the matter so and so. In the meantime, proceeding before so and so stays. I'll stay the proceeding unnecessary.
Deeply obliged. Deeply obliged.
Participate if something happens, then all the proceeding can be passed. I'll just come up.
Notice can be issued through IAC.
Notice issued. Issue
Through
notice.
IAC.
Through IIC, my lord.
Through IAC notice. Through IAC.
Lord. Criminal miscase number 334, 2025.
Do you have that? Say, accused is same.
My lord, co-accused. Footing,
Same
same footing, my
In
lord.
case of the co-accused, notice has been
My lord. Same
If that
footing.
issue notice, these tag the matter along with the other matter. Co-accused matter. Okay.
13/9.
When that matter is coming up?
13th.
13th. Okay, these are 13th.
39, 40, both are same.
13 and 40, both the matters. 13 tag with the matter.
40 has not been solved.
Supply the copy. The co-accused petition is coming up on 13th. I'm listing on 13th. 13th. Give your advance copy.
My lord.
Yes. 13 and 40 both. Issue notice tag with the yes.
Indicating my name.
Mr. Maharana's name to reflect. Mr. Maharana accept notice for and name.
Vigilance matter resisting direction vigilance
Last time why they are not writing vigilance? It's very difficult for them to, that's the reason nobody is coming. Tell the registry, wherever there is a vigilance case, in the bracket, at least they should write vigilance. At least they will come. Okay.
41, my lord. Your lordship has heard the matter yesterday from my senior.
41?
Same order will be passed. Same order will be another analogous matter. Only one CC number will be changed. That will be 3196. One CC number 3196. 20.
Okay, the yesterday or day.
Yesterday, my lord and senior was arguing. 130.
That Ramakanta.
Ramakant.
Same order for the 160 case.
Only one CC number will be changed. 3196.
3196.
3196.
3196. The rest of the thing is same, huh?
Yes, well.
3196. Tag kar do 3196 kar tag kar do. Same as it is. Yes.
42. 42 may please.
Inspired with judicial order to release the vehicle that has been involved in the forest office. The opposite parties are not complying with the order. The order is yet to be given effect to my lords.
Sorry? Order.
There is a judicial order to release the vehicle. The vehicle has been involved in a forest offense. The order has been passed by the learned additional district judge Cognizance. The consequential order has been passed by the learned district judge. Your lordship may kindly see annexure 2 and annexure 3 matters.
2. Okay.
Annexure 2.
Yes.
Page 15 matters. Annexure 3, page 22.
Yes. There is a direction of a release of the vehicle.
My lord.
Okay, what happened then?
The order has not been given effect by the opposite party. They deliberately, they are already
Sorry?
Already confiscated. Your lordship may kindly glance page 30 of the order.
Page 30. 30, huh?
Page 13.
13.
Order of the learned 30, yeah. May I read, my lord?
Yes.
Assistant Conservator of Forest from White has submitted a report by letter number such and such, in which it is mentioned that the each Mahindra tractor bearing registration number such and such and survey number such and such are confiscated to the.
Because all these facts have been taken into account by passing the order.
He has to file an appeal before the 11th.
No, see, this order was passed when? This order was passed.
Again, that order.
When is the confiscation order? What the date? Where is the date?
Date, my lord, 15/7/2024.
15/7?
15/7/2024.
15/7/24 is the confiscation, huh?
My.
It was 12/7/2024, my lords.
Huh?
I'm not wrong. 12/7/2024. The date of the order of the confiscation.
12/7.
My lords.
12/7. Okay. When this order was passed? 457 order.
457 has been rejected by the London decision. That has been revision has been filed before the London.
Revisional court has allowed.
My revisional court has allowed.
Revisional court has taken note of the confiscation.
Yes.
Where is that?
View of Sundarbai Ambala has been.
Page 17 minutes.
Yes. Relevant part.
Page 19.
Parameters.
Page 19.
Advancing the arguments.
Page 19, my. Proceeding under additional regular proceeding. And the offending vehicle was involved in illegal transportation of timber without city permit. Admittedly, the actual became registered owner of the offending tractor. The London defense counted in decision.
1 minute, he is arguing. Wait.
Final order of appeal. That before appeal against the final order passed in confiscation proceeding before the higher court, at this stage it would be relevant to refer the proviso under section 3 of section 15. Thereafter 56 has been recorded, my lord. So in this case, the confiscation proceeding in respect of the siege offending vehicle has been completed, certainly by allowing one vehicle to remain on it, unmaintained and lying exposed sun and rain outside the place where the offending vehicle is laying for a longer period, would deem the value. The apex for Sundarbai Ambala has been pleased to hold that it is no use to keep the siege vehicle at the place where it is laying for a longer. For that reason, vehicle has been, although it is confiscated.
Yes, have you challenged the confiscation order?
My lords.
Appeal is pending.
My lords, and this thing has also been mentioned by the Lalit Additional District in the order.
Appeal, where is that appeal pending?
Next, the order of the appellate court, the FAO 110 of 2024. After the confiscation order was passed, the petitioner preferred FAO 110 of 2020.
Or the pendency of FAO, during the pendency of the FAO, the interim release can be made.
My lords.
What is wrong in it?
My lords.
That has been rejected in FAO itself.
No. See, the confiscation order is under challenge. Okay? And the first appeal, FAO, is a continuation of original proceeding. During the original proceeding, which is pending, confiscation proceeding, interim order can be passed for release. Now there is an interim order. You have to release it.
It is a order under section 457 petition, my lord.
I understand it. 457 order is only for interim release. Interim release. That interim release order is in his favor. In his favor. You are not releasing because there is a confiscation order. And he has challenged that confiscation order in FAO. FAO is pending. During pendency, you have to release it. As simple as that. Why are you making an issue out of it?
You know, my maintainability here, my lord. Confiscation proceeding, my lord. He has to file appeal before the.
He has already filed it.
Yes.
It is pending.
Appeal, my lord, that it has to be decided.
The confiscation order is not arrived at the finality because appeal is pending. During the pendency of the appeal, being a continuation of the original proceeding in the confiscation, the interim order which has been passed for release has to be executed. That's all he says.
Case, my lord, where 457 CRPC has been.
Again, you are repeating the same thing. What? 457 is for interim jima. Interim jima. The order is in his favor.
Clearly barred from the date.
The 72 bar I have already passed a judgment. That bar will not operate.
Annexed that judgment. 72. Annexed 6. But let's see.
That bar will not operate, sir. Bar will not operate. You have to release it till the, if in the appeal, if he he fails in the appeal, then he has to surrender it back.
Oh my God. The appeal itself, what will be the result in consequence of that appeal? Pending before the law.
In the interim release, if he loses and he has to give it, therefore the indemnity bond and condition.
In case, my lord, I'm acquitted, my vehicle is supposed to be confiscated. In fact,
You don't argue just in general argument. In the on the basis of mother wit, don't argue. Argue simply in the question of law.
Well, the question of law.
And I'm issuing notice, just response to it. What will happen to the interim JIMA order during the pendency of appeal in a confiscation proceeding? You just answer that.
I have annexed the previous judgments in this case. Annexure 5 and annexure 6, my lord.
First of all, when you argue, if somebody is arguing, don't repeat. Okay? When the court is saying, please listen to that also. Then you damage your case. If somebody is arguing, you overstep, then and the court is asking something, you don't listen, then it is detrimental to your interest. Have patience. You have a good case, wait. Let him.
The question of law has already been decided. In this honorable court, it has been decided.
I mean, that is the reason I'm issuing notice.
Annexure 5 and annexure 6, I have already annexed your judgment.
Yes. Annexure 6 also just see. Just see and tell me. Okay. Yes, issue notice. Yes. Date. Short date. Yes.
43.
Pass. Okay.
4.
Please, madam. Actually, I am in item number 44. This issue relates to 5 complaints under 138 Negotiable Interest Warrant. There was a settlement between the parties, and the settlement was arrived at the pending payment of 11 lakh you will clear. In the year 2023, the settlement was there. And as per that settlement, 9,90,000 has already been paid. What is the remaining amount is a small amount of 1,10,000. 9,90,000 has already been paid. And out of that, actually, 3 have already been withdrawn. Now, I move that I am going to ready to pay the remaining 1,10,000. There is a delay, of course. Then there is a difficulty in quashing that matter or finishing that matter. The reason being that 2 cases are pending. Out of the 2, 1 is transferred to another coordinate bench. Actually, that is, 1 is pending before the JMFC Raurkela, other is pending before the learned JMFC Panpos. That's why.
What is the total due amount? You tell me simply what is the total due amount?
1,10,000 only. Remaining
1,10,000. You deposit 1,10,000, I'll stay both the proceedings. As simple as that.
No, oblige. I shall deposit 1,10,000.
And he will come and take the money and finish up.
Yes.
Okay, subject to because you in the prayer you say that 1,10,000.
Yes.
In the prayer you say 1,10,000.
Your Honor, I have appeared suo motu in this case. The complainant.
Why don't you? He is giving the money. Why don't you take it, sir?
No, sir, it's a different story. I'll give my objection and make it clear. He is misleading. Sir, I have appeared today voluntarily, Your Honor, with a memo that kindly he may be directed to give me the copy of the petition as well as IA, and I'll file the objection to it.
Okay, but what I'll do is I will ask him to deposit at 1,10,000 at least. Let it come first.
Yes, sir. He may. I have no objection.
Then we'll hear you. Okay.
Any amount he may, sir, deposit. I have no objection.
Any amount.
No, any amount. In the prayer he says 1,10,000.
Sir, after all, it is coming to me only.
That's right. That's right. At the end of the day, it is a money matter. You have to get your money back. That's all.
Sir. But in this petition, there's something more to be heard and pondered, Your Honor. So he may
don't argue on technicality. You concentrate on your money.
It is not at all technical, sir. It is pure fact.
Okay.
But I may be given chance to file the objection. He may be given direction to give me the copy of the petition as well as IA.
Okay.
Either by PDF on WhatsApp or the other side is also local. He may.
That I shall do.
I'll direct that. Okay.
Yes, Your
Issue notice to opposite party, Mr. Jagdish Singh Chavra, on advance notice appears and accept notice for opposite party. Learned counsel for the Mr. Pradhan, learned counsel for the petitioner, undertakes to deposit 1,10,000 rupees. Before which court you want to deposit? Which court?
Before
Before
Lanet
the
Alcala?
Learned JMFC, before learned JMFC Raulkela in ICC case number 362 of 2008. DC matter on
Another matter that is 363 of 2008 that is pending before Lanet JMFC Panpos, because they are transferred earlier, they are with the same bench, same court.
You know, let me file the objection, things will be clear.
Let him file objection. Yes, yes.
Okay, he will be directed to give me the copy of the petition as well as.
And Mr. Pradhan undertakes to supply the copy of the present petition to Mr. Chavra.
Either by WhatsApp message or local, Your Honor.
Yes,
I'm available both.
Through the local council.
Local council party is also local, Your Honor.
Through the local council.
Okay. In both the cases, they should not proceed. That is what I am saying.
No, both the cases you have filed one case only.
Yes. That should not proceed. I shall move an application in that case.
Then you will in view of petitioner is granted liberty to take whatever 360 years or stay for the.
Your Honor, my memo of appearance may be accepted.
1 minute. 44th item.
Yes. 363 of 2008 in before Lanet JMFC Panpos in complaint number.
Pampos.
JMFC Panpos.
Insofar as connected the case 363.
Up 2008.
Okay. 363 of 2003 to pending before the court of JMFC Raulkela Agriculture. Petitioner the liberty to move application seeking urgent. Yes.
Sir, my memo of appearance may be accepted, Your Honor.
Yes.
May I please, Lordship? Lordship, this is a Belgium matter. The petitioner number 213 surrendered in the lower court below on 22/1/2019, and petitioner 1 was surrendered on 15/4/2019. That is at page 17 and 18.
17 page 17, 18 of the petitioner
Thereafter,
and
Lordship,
NBW issued on
13/12/2023.
13/12/2023. Okay, 500 each. Yes.
46.
May it please, my lord. Well, this is a matter of quashment of the charge sheet filed against the petitioner as director of one company, my lords, namely Tarini Industries Private Limited, on the allegation that it has received some financial credit facility towards procurement of iron ore, my lords, and thereby those financial facilities received, the allegation is, have been received on the premise of misrepresentation with respect to its financials. On that, the charge sheet now is filed under 120B 420 IPC 7B 910 of the Prevention of Corruption Act.
Yes. What are the grounds then?
Look, if your lordship comes to page 66.
66, okay. Yes.
The 16.2.
Yes, 66.
16.2, my lords.
Yes.
It is alleged in the complaint that the directors of Tarini Industries had approached the PEC Limited.
You are one of the directors.
I am one of the directors, my lord. PEC Limited is a central PSU, my lord.
Yes.
For granting financial facility for domestic procurement of iron ore and coal, in pursuance of which an associateship agreement dated 5/10/2012 was executed between PEC Limited and Tarini, my lords, for purchase of iron ore to the tune of 8 crores by Tarini Industries. Later, the financial facility was extended up to 19 crores via addendum agreement number such as dated 13/39/2013. It is further alleged that directors of Tarini have submitted representations, including misrepresentation and concealment of facts regarding the financial position of Tarini to PEC for sanction of the finance to the aforesaid company on different dates, my lord. My lord, this misrepresentation in fact relates to certain stocks which were hypothecated in favor of the central PSU. It is alleged that those already stood hypothecated to SBI Bank. So there is a double charge.
You have created second charge.
Yes, yes, without informing them. That is the sole allegation, my lords. My lord, to that respect, my lords, PEC Limited initiated NCLT proceeding against me under Section 7 of the Insolvency and Bankruptcy
But
Code.
you,
my lords.
19 checks, you have given some 11 posted checks of 19 crores given to PEC of Matarani were also
Yes,
dishonored.
who also
138 proceedings are initiated against you.
138 proceedings probably have not
11
been
cases
initiated.
posted 19
Yes.
crores.
Yes.
For the security offers of PEC from Matarani.
In 2019, my lord, they initiate NCLT proceedings.
TVS lifters, TVS, which is willfully concealed. Yes, there are two-fold allegation. One allegation is you have created the charge in so far as the mortgage property is
Is concerned, my lords.
and you have concealed that and created the
Second charge.
And the second allegation is 11 checks were given by you amounting to 19 crores to PEC, which has been dishonored.
Dishonored, my lords.
Yes. Yes, Mr. Naik.
Your Lordship, may kindly come to page 8 in the prayer.
8 prayer, your prayer of the petition.
Yes, the prayer is to quash the FIR, Your Lordships, and he's arguing on the charge sheet. Let him amend the prayer, then the matter can be taken up, Your Lordships.
Oh, now what else?
In the circumstances, most respectfully pray that the Honorable High Court may please to admit this application, call for the records, and after hearing the
Only charge has been filed. Charge sheet has
Charge sheet has been filed.
Why don't you argue all this point at the stage of framing of charges?
Yes, and cognizance has been taken also, Your Lordships.
Cognizance has already been taken. You see, I can't read everything and I can't ever. So better that I will give that liberty. You file an application for discharge, and the court should deal with this. Whether any criminal act has been done by you or not, when the charge is made against you or not.
That is his, Your Lordship, Lordship, he may simply withdraw it and all the remedies available are under
I'll
the law.
give that liberty to you.
Yes.
Give that liberty to you.
Well, I will withdraw.
Withdraw, otherwise you withdraw with reserving your liberty to move application before the trial court for seeking discharge.
Yes.
Let Mr. Das, let counsel for the petitioner seeks to withdraw the present petition with the liberty to move appropriate application before the trial court seeking discharge. If such application is moved, the same shall be considered on its merit by the trial court. With this of the observation, the petition is disposed of.
Yes, sir.
Disposed. Yes.
47. They have been acquitted on their condition. Fact of the case is made.
Why were you absconding?
Actually, also, a BP was coming. It was stopped on the way. And police on suspect went to the vehicle, find no person was there. The vehicle was not the owner on the basis of the ownership, the wife, one lady was arrested. He confessed that my husband and I were transporting the ganja in our vehicle on the instigation of this petitioner. It is 1 and 5. No other.
Who are you, Imran Khan?
Imran Khan. Your Lordship, my kindly see this
And the
document
accused
has-
person made their confessional statement that the instigation of one Imran Khan,
Yes.
Jaipur,
Also,
they were involved alleged crime. Yes.
Your Lordship, my kindly see.
You are the main accused. You are the principal accused.
Yes.
According to them.
Yes. What they have said, vehicle belongs to them. They are the owner. The ganja loaded in their vehicle. They were arrested. They confessed. They acquitted.
They are acquitted.
But again, also finding of the trial court
Yes.
is standing
Where is
in
that?
case 32.
32. Okay.
Yes.
Yes.
In this instance case, 1125 kilograms of ganja was smuggled in the vehicle of accused Vanita, which was being driven by accused Sudarshan, who is none but her husband. When the accused person made their confession that on the instigation of one Imran Khan, they were involved in this case. Well, this is one point. What is left to be considered, that I want to draw your attention. But then page 33 or something, except the informant, clause E,
Yes, informant. None of the official witnesses
stated that the contraband activities were seized at the spot. That is one thing. F, clause F, the documents, last line, which is indicating the fact that documents were prepared and the police were not at this spot. This is the finding of the trial court. The IO has not produced the EG. The IO has not produced the evidence. The contract, whatever case and nothing. Nobody says nothing. That is the finding of the trial court. I am not saying it. The remittance, the contraband in post for trial after taking something that's from protesting. But where is the ganja? Nobody knows. Then the illustrative can see G, H, the way was made by the OIC himself. That is the finding. Then my lordship I, the stationary entry which refers the informant and his team were on patrolling duty has neither been seized nor
chemical examination report is placed.
That has been disproved.
Yes. Where is that? Where is that? Where is that? Finding?
Yes, that is. Yes. There are also page 42, page 42. 42 para 24. Towards last 4 lines, the command certificate issued to the constable who had taken the exhibit to the RFSL by exhibit 21 shows that the same was issued on 3/9/2020 and he handed over the sample packets at the RFSL on 4/9/2020. However, said constable has not been examined by the prosecutor in this case. There is no possible explanation given by the prosecution that where the sample packets were kept after being directed to be taken on the RFSL from 1/9/2020 to 3/9/2020. In that regard, as the IOPW 15 in its cross-examination has admitted that there is no reference to the soul in which place.
Yes, madam, what do you say?
The entire thing has been.
My lordship, because of the this.
You have no evidence at all.
Yes, my lordship.
See, the ganja which was seized from Malkhana, nobody knows where it has gone.
Yes, my lordship, I have seen
the chemical examination report is not proved.
Yes, my lordship, but
even if you put him in trial, what will you get?
My lordship, one thing is that once the name was come out after investigation, let him to appear before the lower court, my lordship.
No, for what good reason? You tell me. Is it not a burdening the court?
My lordship,
only for formality?
My lordship, one thing is that after investigation, they come to know that the Imran Khan is also the accused, my lordship, because in the.
You tell me, except confessional statement of who the co-accused, what material do you have against him?
No, my lordship, I will take the instruction, my lordship. Kindly keep it.
And I have a one judgment. Say that chemical analysis report is there, so therefore the entire case I quashed. Because even then he was absconding. Because see, these are mere formality.
Yes,
now, even if you put him to trial, the kind of evidence, chemical analysis report disproved. The ganja seized when he's from the Malkhana.
But it's a principal accused because by his instigation they are saying that my lordship.
Just see. The only thing which is against him is he was absconding.
Yes,
issue notice, let us see. Issue notice. Also. Have you appeared?
Yes, sir.
Already appeared before court? No.
No.
Still absconding.
No.
Still absconding. You appeared. At least you should.
Absconding, I taken in question. There is no doubt about it.
Be there for a week or so. I'll quash it. Surrender. You should face the blunt of it.
For moment,
you do one thing. You surrender. I'll put it and I'll quash it.
Yes.
He was in interim bail, my lordship, but still he was not surrendering even if the date was fixed.
take instruction, for a moment you must be protect me, I will surrender definitely. After the.
No, why should I protect? I will not protect to
There is something.
absconder. I will not protect.
Yes.
You have to face the due process of law. You have not done it. But since unfortunately they fail to bring on record any evidence, you get benefited. That's a different story.
Sir, fix up a particular date.
I am not fixing a date. I am not saying anything.
Particular date.
I am not saying anything. I have just fixed it. Issue notice fix on. Let it be on 20th.
No, you can be direct.
I will not direct. It is your out.
Fix up a date for final hearing. That's my plan.
Okay. Issue notice so and so, and Mr. Maharaja and counsel for the petitioner has then I have to write the full text of your argument.
Yes.
Has submitted that the out of how many accused total?
Three.
Out of 3 accused, 2 of the co-accused face the trial, and the learned sessions judge come special judge Malkan by his judgment dated 26 November 2024 record an acquittal in favor of the 2 accused, 2 co-accused. And he has taken me to the findings of the learned sessions judge recording the acquittal in favor of the co-accused person. Mr. Maharaja has emphatically pointed out that neither the neither the prosecution could not prove the chemical analysis chemical examination report and the alleged seized ganja of 1125 kg which was kept in the Malkhana could not be produced before the court, and apart from that he has also pointed out the glaring lacunas of the prosecution case. Besides the fact that the executive magistrate who has
The improvement did not take any pain to procure any executive magistrate to at the time of seizure.
the executive magistrate has also not been examining the present case. It's not even the prosecution not even attempted to call for any executive magistrate at the time of seizure and seizure. At the spot of the seizure and preparation of the seizure list is also has been doubted by the legislation judge. Issue notice to state this Maharana accept notice. At this stage, Mr. Maharaja submits that his client would appear on the surrender before the court below on or before 20th of March 2020 and restore to the remedy available to him under law. Under law, release the matter for final disposal on 21st.
Yes.
You surrender and at least be there for a week or so that yes. Yes.
May I please, your lordship? My lord, here there is a dispute between the directors of a construction company, my lord. The opposite party number 2 and his wife and the present petitioners, they are all directors, my lord.
All the petitioners are directors.
Yes.
All the petitioners as well as the opposite party number 2 and who is the informant and his wife. All are directors.
Directors of
a construction company, my lord.
Okay.
My lord, now, my lord, there was a dispute arose between the directors, my lord. The opposite party number 2 and his wife both went before the NCLT, my lord. NCLT, they filed a case. We also filed a case, my lord. The NCLT, they filed an application for interim restraining us from dealing with the transaction of the company. That application was rejected. And on the other hand, the NCLT gave us, the petitioners, the authority to transact the bank account, my lord. Okay. Now, and to furnish the accounts, my lord, on each 3 months, my lord. We went on filing the accounts, my lord. There is no allegation before the NCLT that there is any, my lord, difference.
He has gone for
now, my lord,
mismanagement.
Now he filed my lord, several complaint cases making allegation that we have embezzled the funds, my lord. My lord, 4 cases. Your lordship has been pleased to pass interim orders, my lord. And thereafter, another 4 cases, your lordship also passed the interim order. 8 cases all total. My lord, your lordship has
8
also.
cases she has filed against you.
And now this is another case which has come to my notice very recently, my lord. And today also.
9th one.
Yes. And today also, I found 2 other cases the wife has instituted, my lord. These are all the cases, my lord. The NCLT has already passed the order removing them from the directorship, my lord. Under Annex 2, my lord, the NCLT has already passed the order finding fault with them and removing them from the directorship. And now, my lord, he is going on filing repeated cases only to trouble the petitioners, my lord.
No, this is filed by.
I have given 5 cases, my lord. 4 cases by 2 petitioners and 4 other cases by other 2 petitioners, my lord. Now, my lord, this is another case. And today I have come to, it has come to my notice, 2 other cases have been filed by his wife. That also I will have to file, my lord. All the cases will be taken up together and
Interstate dispute between the directors of a company.
And NCLT has also.
If you they have approached the NCLT for mismanagement, and that petition is dismissed.
Yes.
So the question of mismanagement doesn't
arise, my lord.
And since he lost there, by way of arm twisting, criminal cases are being filed.
He is going on filing complaint petition. Actually, very surprisingly, the London magistrate is repeatedly sending it to the police station. Police is unnecessarily harassing me.
Notice to opposite party number 2, Mrs. Marana accept notice for the state. তার উপর লেখো, Mr. Mishra, learned counsel for the petitioner, submits that the present opposite party number 2 has initiated as many as 9 cases.
Total 7 cases have come to my notice, my lord. 4 cases, your lordship have been pleased to stay.
Multiple cases.
Multiple cases.
Initiated multiple cases, out of which the petitioners could gather the knowledge of only 7 cases as yet.
As on today, my lord.
He further submits that the where is the NCLT order?
NCLT order is at Annex 2, my lord.
Annex 2. Submits that the opposite party informant had filed a petition before the which NCLT Cuttack under section 241 and 242 of Companies Act against the petitioners, those who are the co-directors with the complainant. The NCLT rejected the application of the petitioner by disbelieving the allegation of mismanagement.
Mismanagement, and the NCLT has also
out of vengeance, the opposite party has resorted to these proceedings under the criminal, resorted to the present proceeding, and the criminal law is set in motion against all directors. Issue notice, and in the meantime, proceeding before so and so is stayed, and tag the matter along with this. All the matters.
Your lordship may say.
Matters are coming up.
Your lordship may say no coercive action to be taken. Because police is unnecessarily harassing us, my lord.
But coordinate bench has passed no coercive action.
I guess it's no coercive action.
No coercive action. Coordinate bench.
Gote moro chotiya mistake he jaichi.
Coordinate bench has passed.
Gote chotiya mistake he jaichi. Se miscase re city case number ta 49 jagare bhul le padi jaichi a gote number ta. I may be permitted to correct that, my lord. Miscase.
Submits that there is a typo. A space.
Miscase prayer portion.
Typo in the prayer portion of the
IA prayer.
Prayer portion of the IA.
Prayer portion of the IA.
IA.
Seta.
He may correct the same. He may correct the same. Yes.
The 49 of 2020.
Proceeding correction kala par juda habo static to. Yes.
49.
49, I mean, VC, my lord, that appeal against an order of conviction the petitioner has been convicted for the offense alleged, that is 13(1) CD,
2 years.
and
2 years.
sentencing him to 2
Okay.
years
Okay, Mr. Sanjay
and
Das.
fine.
Okay. Yes.
May I please?
Yes.
That's the order. Next to the confiscation 11 and 12 and 2025 passed by the Law Court of the Authorized Officer Special Court of Bhubaneswar, my lord. Confiscation case, the demand the dowry 15B of Orissa Special Court Act directed to deposit the amounting the 3 crore 10 lakh 82,1815, my lord.
It is appeal issue notice.
Yes, sir.
Yes. Who is accepting notice? Vigilance, huh?
Yes, ma'am.
You accept it. It's for appeal. Yes. 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 Next. Huh?
51, my lord,
Yes.
yesterday I have already filed my appearance memo that my name may be reflected.
Name.
Interim order.
I'll say the interim order, otherwise.
The depositing the amount.
So, but
Yes.
subject to deposit from someone.
Subject to deposit. You see what is the general order? Subject to what is the amount?
Because
Amount 3 crores
3 crores.
3 crores 10 lakh 82,1815.
Bank guarantee.
Bank guarantee.
Bank.
Bank guarantee. Subject to furnishing bank guarantee to the tune of 3 crores.
3 crores 10 lakh 82,000.
3 crores, correct, 3
Yes,
crores.
ma'am.
Subject to furnishing bank guarantee of 3 crores. The operation of order dated, judgment dated 11/2/2025 passed by
Authorized Officer Special Court
authorized
Bhubaneswar.
officer. पूरा लिखित होगा.
Special Court Bhubaneswar in confiscation case number
Confiscation case number
2 of 2021.
2 of 2021 state. Yes.
For 3 months, because statute says for 3 months.
For a period of 3 months.
3 months. And they will deposit by
Within 15 days.
Yes.
Deposit within 15 days.
Yes.
Ah, 1 month. Okay, 1 month. Lease the matter after 3 months. Yes.
51, your lord. Appeal for admission, your lordship. Conviction under section 13(2), 13(1)D.
How much
Appeal.
sentence?
3 years maximum,
3
your
years.
lordship.
Okay. For the stay, realization of fine also state. Yes. Mr. Das appeals. Read agreement. Okay.
Connected appeal are ending out of self here.
Yes.
265.
Read the matter.
There is I for bail, your lordship.
Bail grant. Yes.
52.
Item 52, I may be permitted through VC, my lords. My lords, Belgium matter, my lords. And NBW was issued on 8/10/2024. That is at page 9, my lords. Prior to that, he was on bail by order dated 23/8/2023, my lords.
2020? Bail on?
Bail on 23/8/2023. 23/8/2023.
23. Okay. 500. Yes.
53.
Next item, my lords, a Belgium matter, NBW on 2/8/2022. And he was released on bail on 10/6/2016.
Okay. 1,000. Yes.
54. NBW 26/12/24 minutes. Bail at 21/5/9 minutes.
Okay. 500.
55. May I please, my lord? May I please, my lord? On prayer of IO, NBW was issued. Subsequently, charge sheet was filed. And also, lordship.
The petitioner was sworn as an absconder on the prayer of the IO. NBW has been issued against him on 24/8/2022. Yes. 500. Yes.
56.
This is a Belgium matter, my lord. Earlier petitioner was on bail, my lord. NBW issued, my lord, 10/4/2023, my lord.
Bail date.
Bail date is not there, my lord. He was on bail, my lord. Earlier.
General counsel for the petitioner submits that the petitioner was admitted to bail in the however, due to appearance, NBW was issued on 10/4/2023. 500. Yes.
57.
May I please, your lordship? My lord, NBW was issued on 18/12/2024, my lord. There are 4 petitioners, my lord. Petitioner number 1 and 2 were surrendered and released on bail on 7/1/2016, my lord. and petitioner number 3 on 13/12/2021, my lord, and petitioner number 4 on 22/1/2020, my lord. 2020.
And it will be issued on 24. Okay, 500 each.
There, immediately should be prosecuted by the same order as the.
Why decision? You tell me. Prayer of IO.
Yes.
You are responding.
Yes, definitely. The prosecution is para 2 and 6.
What will you do with the judgment? I'll pass this out. Right, on the petitioner.
My lord,
Okay, petitioner was shown as an absconder while filing charge sheet in the present case on 28/8/2022 on the request of the IO. NBW has been issued by the court below by the order dated 28/6/2022. First, 500, yes.
Bail on
Subject to appearance.
Yes.
Bail on my lord 6/3/2017 and NBW on 4/11/24.
24.
24.
Okay, 500, yes.
66 12 to 2004.
25, okay. Mail. 500, yes.
61.
Not trace for the petition number 2. Date of NBW issue on 4/2/2025.
No, not press petition number 2. The present petition is not pressed. Petition number 2. The petition number 1.
Date of
was
bail 1/11/2021. NBW issue on 4/2/2025.
25, 500, yes.
62. Chairman absconding NBW dated or not the other topic.
Same like the on the request of the IO. Issued. Yes. So no, 24 na. First let us finish it. 500, yes.
Surrender before the trial court. Trial courts are considered my application.
I will not deviate from the standard order which I have. One thing is there. If you have a judgment, you the court will not listen to you. Unnecessary guiding the courts in this fashion. You have a judgment in your favor, you cite it. Cite it. Mr. Panda, on instruction submits that he would appear, the client would appear 3 and resort to the remedy available to him under law. He also submits that he would move bail application relying upon the judgment of Tufan. If such application is moved, same circumstances on its merit. That I have said. Yes.
63, my lord, the petition number 1.
Execution of NBW that is so and so, issued on so and so, shall be kept in events till 30th. So, yes.
63, my lord, the petition number
63.
My lord, petition number 1, my lord, released on 15/2007, my lord. And
yes,
my lord, petition number 2, my lord, 19/10/2006.
Okay.
And NBW both, my lord, 5/9/2013.
13.
My lord, FIR is the year 2005, my lord.
Okay.
Unknown FIR, my lord.
Okay. 1,000 each करके कर दो कम बताओ.
64.
May I please go? My lord, NBW was issued on 24/4/2024, my lord. The petitioner was released on bail on 30/9/2022, my lord.
Okay. 500.
No, one prayer, my lord. Urgent copy of this order will be issued today, my lord.
Everything is urgent, don't worry. You are absconding,
The
NBW is issued now, so urgent.
petitioner mother has died, my lord. So
Died. I am giving you, I'll set aside it. There is no, I am giving a date of 30th.
my lord.
Don't worry. Today only we'll get it, don't worry. At the priority to go.
I think only there are deactive persons are that who have been religion. I pray after second and parity.
No, you appear, move up.
The 302 offense is there, the one magistrate has no power.
No, 302, I will not say first hour, second hour or not. NBW, I can to that extent, I'll keep it events and.
Kindly bear for a moment. The after 2 months of the occurrence, FIR has been lodged. In fact, case is that they have fallen from the.
Oh, I will not go on the, I'll not, indirect way of doing it, I don't do.
I only try to be first or second and parity, I surrender for the.
Parity, if you have, very good. A petitioner has been absconding. Petitioner is an accused in FIR number.
For number 56 of 2015.
For alleged commission of offense under section, बताओ.
302, 307, 320, 325, 534.
Yes. The charge sheet was filed in the present case on.
Filed on 17/7/2018.
For the aforementioned offences, petitioner was shown as an absconder. On the prayer of the investigating officer, NBW has been issued against the petitioner by the order dated
18/12/19.
18/12/19. Just see, in one murder case, you don't go.
I have filed bail application.
That is rejected. Where is that order? Then now how can I pass this order?
No, man, that is withdrawn. I have mentioned the para 7 of the.
30th April. Counsel for the Mr. Pollard will counsel for the petition for further submit that the co-accused persons have already been enlarged on bail, so he is entitled to parity. 1000 to be cost करो. The execution of NBW is kept in the range. Sealed. 1925. Subject to petition surrendering before the court below and the short to the
Both the courts.
कर देख रहे ठीक
Same day.
yes
Both the courts same day.
yes I have done it. Yes.
Okay.
66.
Two 2008. Not the review petition, not even the impugn order is filed. No, is there impugn. Password code should लिख दो. I know. The review petition has been filed on 4/4/2008 against the judgment fine. Against the order dated 13/2/2008, whereby the single judge of this court, while setting aside the judgment of the DC Judge Kalahandi and passed in PA case number 1 of 1985, dated 12/5/1989, has remitted the matter back to the trial court. Remitted the back to the first appellate court. The operating part of the judgment treats as under page 8, the last paragraph. The review petition is pending since 4/4/2008. None appears for the petitioner. The even the office objection pointed out by the SR has not been cured. Hence, the petition is petition deserves no merit, accordingly dismissed. Yes.
7.
Same concept. Same concept. The review petition is pending since 12/5/2008. The registry had pointed out several defects. However, the same has not yet been cured. Even on merit, the review petition doesn't satisfy the required parameters of Order 457 CRPC. Hence, the petition is dismissed. Yes.
68.
The
Yes.
review application has been filed. For
Yes.
review of the order dated 11/5/2015.
11/5.
Yes.
Yes.
Order annexure A/3, page 11.
Yes.
Wherein the petitioner, the additional court has granted relief to the petitioner. The Lordship, page 12. In view of the aforesaid law laid down, this court is of opinion that the petitioner is entitled of headmistress for period worked in charge headmistress. The opposite parties are directed to calculate her entitlement at the scale of pay of headmistress for the period for which she had worked as stated. She is continuing as such and to pay such salary to her, deducting
Yes.
the amount. This is the
Operating part of the order. Yes.
this is the, in fact, in this case, we have not given a chance to file our reply. Why? She is not entitled to get all this benefit.
Because in the main writ petition, you have not been given opportunity to file.
Opportunity to file a reply to
Reply.
the same. We have taken ground in paragraph.
Then you are saying that principle of natural justice is not followed.
Yes.
Is that a ground for review?
No. Then
file appeal and go and tell the appellate court saying that no opportunity was granted. Principle of natural justice is not followed. Is principle of natural justice a ground under Order 47? How will you maintain this review?
Then other one ground is that we have.
You
not-
show me what is the error apparent on record.
Apparent on record is that she is not entitled to get the salary.
That the appellate court will decide. The review court will not decide. You have a good case on for appeal. You go and file the appeal. Who stops you? How can you maintain a review like this?
We have even the documents here we have annexed here in is establishing that she is not entitled to get the salary. That is annexure C/3, page 15.
Is
15. That is office order issued by the Inspector of School, Sundargada Circle.
Let us see whether notice was issued to you. You didn't go, or let us see in the writ petition what happened.
No.
Was it done in the first day?
First day, yes. At the stage of fresh admission.
Notice was not even issued.
Yes.
Then I'll have to issue notice. Issue notice. Yes. See, it's not a case of principle of natural justice. What he says is there are some documents.
No, my lord.
If those documents would have been taken into consideration,
Yes, Lord,
the order would not have been passed.
Lord.
So then order 47, he is covered by the order 47. And even notice was not issued. You file the writ petition, it is allowed.
You must kindly see, including this matter, 400 cases filed may be before this Honorable Court. In main case, they have stated this stand before the Honorable Supreme Court, which is the annexed, my lord,
Yes.
in the review petition.
Yes.
That review petition is that SLP is dismissed and direct to file a review petition before this Honorable Court. Thereafter, they file the review petition in the main case as well as all batch cases.
Yes.
Finally, the review petition was heard and disposed of by a divisional bench. An order was passed, modifying that order. You make payment in the review, main review, my lord.
Yes.
Thereafter,
That you are talking about Dilip Kumar.
Yes.
Dilip Kumar Sahu.
No. Dilip Kumar Sahu is the one case, similar matter. They are working as
What happened to Dilip Kumar? Relied upon judgment.
They got the benefits. That is, he work as a court master, my lord. But the salary is released the ASO post, junior assistant post, my lord. For that reason, he filed case before the lordship, my lord. This Honorable Court directed, now he is working, even if his post is ASO or junior assistant, he is working as a court master.
Have you filed the counter to this?
Review, my lord. First time is coming under the head, under delay, my lord. That delay should.
Where is the delay?
Yes, man.
159 days delay.
Are you going to file reply to delay? On the ground of delay, I'll dismiss it.
Yes, my lord. On the chief postmaster, my lord. General.
The ground of delay, I'll dismiss it. Pay the amount. Why unnecessary?
He is not entitled.
No, my lord.
But he may not be entitled. But in the other cases, you went up to Supreme Court. You lost everywhere. Everywhere. You paid everyone. And
they have complied with 400 cases. For your lordship's permission,
Produce all those.
All those.
Then do one thing. You file a short reply. I'll take into consideration and dismiss.
Your lordship, the similar review petition dismissed by this Honorable Court. One case, your lordship kindly see. One order.
Please place those things on record. I'll put it next week. I'll dispose it up.
My lord?
Next week I'll put it. You file a short reply. I'll take that.
On the ground of delay, my lord.
Delay as well as those.
Actually, they have lordship. They have filed.
Do you have any problem? I have to take that into consideration.
400 cases they have complied.
I understand it.
400 cases.
I want to dismiss it, but I need something to write also. You just file 2-3 pages reply. I'll put it on 12th.
On the ground by delay.
Delay. And those orders also, please.
3 coordinate benches dismiss the review petition.
All right, my lord.
File 2-3 orders.
And after the main review, again they also go to the Supreme Court. Supreme Court dismissed and directed to implement the order with 12% interest from the date of order of the Honorable High Court.
Place those orders.
Yes.
12th, huh? 12th.
Yes,
my lord.
12th. The best thing would be to dismiss it on the ground of delay. At least you get an opportunity to go to Supreme Court and get the main.
Because they have 400 cases they have already implemented. Because of this review petition, the petitioner is not entitled to pension. They have filed the review petition on the ground delay.
12th I'm keeping, don't delay it filing. I'll show that.
Yes, my lord.
Yes. Yes. Sir.
Can you make a prayer? Both are here. Can we dismiss?
Give me.
Arising out of PC case. Our has been passed 11.
Now, have you settled? Give me that if you have written.
Now, I have got the order, similar order, in which on call.
You just correct it and give it, sir. I'll pass it. Pencil the correction.
My concern.
I know that I'll not write.
8,20,000.
You write down there in that order. You have given consent. I'll write.
How
820, huh?
Yes. 11.
8,20,000. The name changed. You have not changed the name. I'll do that. Don't worry. What is this? This is your. Oh. The judgment is already there. The appearances.
When parties agree, usual order is that court quoted this amount and to which he.
I am passing those orders. Court, I am quoting, it fell from the court and you have agreed to that.
He agreed, I disputed, but your lordship fixed it.
You could do now. 8 lakh.
20,000. 18 ছেলে ছিল সে ধর কাটি দিবেন যে আর পুরে
Thank you.
70 lunch for 7.
I don't know like I mentioned, my lord. So one weekly list matter charge so again by business case matter. It has processually completed. And written order argument citation already filed to the law and government argument. After launch, I claim.
Get ready, we'll see who can take it up. Yes.
It's that matter which was mentioned in the morning. My senior Mr. Manthi.
Yes.
No, pardon me, your lordship, we have found out, let it come on 11, my lord. Your lordship has already fixed it on 11, then your lordship has also
I
informed
will
that
just
your
make a
lordship.
small request to that effect. If the matter comes up on 11, Mr. Parija won't be there. May I be accommodated on that day? Is all that I'm making.
Okay. On that day, you can.
I will have. Great.
Deeply obliged. Great.
Item 19. 19, my lord. The national list matter has already come.
Yes.
My lord, I am appearing for an informant.
Where are they?
It's not husband. 1 is husband, 2 is mother-in-law, 3 is
Where is
kept
the
up
affidavit?
opposite petitioner 1.
All of them are present. What? All 3 of them are there. At the instance of opposite party number 2, FIR number came to the petitioners and allegation petitioners also. What is the stage now? After investigation, charge sheet in the present case has been filed on
6/4/2016 also.
For alleged commission of offences under section. Sections tell me. 498A.
323.
Yes.
426. 34.
Yes. What is this page 14? What is the judgment? Before the trial could commence, the parties have entered into a settlement and settlement. And on the basis of settlement term, the present petition has been filed. Suman Mudali's petitioner number 1. Petitioner number 1 and opposite party number 2 had applied for resolution of their marriage by mutual consent under section 13B of Hindu Marriage Act. The family judge Jagasingpur the judgment dated 18/7/2024 in civil proceeding number 266 of 2023 has allowed the petition and dissolved the marriage between the parties parties on mutual consent. Consent. Amount. Who is the informant? Just ask informant. Pursuant to the settlement term, the permanent alimony, agreed permanent alimony has also been paid to the opposite party number 2. The petitioners and opposite party number 2 are present in the court. The opposite party number 2 is present in the court. On the query from the court, submits that she has already received the permanent alimony and had given consent for devolution of the marriage. Accordingly, the family judge was so and so passed the order, passed the judgment resolving the marriage. The amendment Mahanti is for the state and submits that the matrimony, the dispute is arising out of matrimony and discord. Parties have settled the dispute. They have filed the affidavits before this court. Star upperly affidavit. Opposite party filed the affidavit. Para number 22 for Uttarwin. Yes.
Item 15.
Huh? 50. 15. Reverse 15, yes. Yes. See, somebody was asking for adjournment.
Since last 3 days, that happened. Last week also, he sought for time, and in spite of my lord's order, even he is not bothered to serve copy. So also kindness in the prayer, but he is challenging. On this ground, they are seeking time there to frame charge, but here they are seeking adjournment. The court.
Then I'll make it clear that pendency of this petition shall not.
We are tried to pass entire proceeding on what ground, what order you are checking, nothing has been mentioned in the entire petition. So also kindly see the prayer.
Yes.
At page.
Yes, page 9.
Petitioner praised before this order to admit issue notice, call for record, after the both sides, the provisional record documentation was the entire proceeding, and annexure has been made to the order passed by the adjudicating authority. Against adjudicating, you will also kindly see the annexure to against the order of adjudicating authority, there is a separate provision is there to file appeal before the appellate tribunal. Only just to delay the trial, all this, it's a chick fund scam, more than 300 crore.
No. I'll dismiss it with liberty to him to file a press one.
If they have cause of action, they can always file. But even not.
And he has not filed anything.
Nothing has been filed below. Even he is not bothering to your lordship's order to serve me copy below, in spite of thrice direction has been given.
Non-appears for the petitioner on the second call. When the matter was taken up in the first session, the counsel on behalf of the counsel for the petitioner, an adjournment was sought, which was opposed by the vigilance counsel. In the second call, non-appears. Mr. Agarwal appears for the vigilance. Submits that despite the matter was taken up thrice, the copy of the petition has not been supplied to him. However, from the supplied to him, he submits that in the present petition, the petitioner is seeking quashing of the entire prosecution, entire proceeding arising out of C&C PMLA number 84 of 2020. Perusal of the petition reveals that except the adjudication order passed by the competent authority, no other document has been included with the petition. Regarding head to the aforementioned, I am not inclined to entertain this petition at this stage, hence the same is dismissed with liberty to the petitioner to file a fresh petition including all necessary documents if the cause of action subsists. With this observation, the petition is disposed. Yes.
23.
Yes. non-APS for the petitioner, even in the second call, in the interest of justice, shall judge. May or last. Yes.
26. May I please, Your Honor? My lord, in this criminal miscase, the petitioner has challenged the order dated 27/3/2024, wherein the petition filed under section 227 of the CRPC for discharge from the criminal charges has been rejected by the learned trial court, my lord.
Yes.
My lord, that is impugned order is at annexer 5, my lord. Page 28. 28.
Yes.
My lord, the operating part is at page number 29, para 4.
Yes.
The counsel of the accused has argued that the accused Naresh Masi was performing his duty at his service place on the alleged day of occurrence, and he is not connected with the alleged offences. In view of second illustration A of section 103 of Indian Evidence Act, here burden lies upon the accused Naresh Masi to prove that he was at his service place on the day of occurrence.
What is wrong in it?
My lord, though I have not filed the documents, my lord, before your lordship,
But it has to be established. See, the plea of alibi.
My lord,
You
my
are
lord,
an accused in 3-2 case.
my lord,
Plea of alibi has to be established.
my lord,
That's what it says.
the annexer
And 103 evidence says that.
my lord, but annexer 6 I have filed before your lordships that the accused was in service place, my lord. That
But
is page.
it is completely forbidden for a 482 court to go into all this.
My lord, a small prayer, my lord, I may be permitted to given liberty to approach afresh before the learned trial court, my lord.
You have already approached and rejected.
Along with the documents, my lord, these particulars has not been submitted before.
See, this has to be. That's what the court says, that you have to establish,
My
because
lord.
the burden lies upon you
My
to
lord,
prove.
my lord, annexer 6 series, I was in
That
service.
has to be proved by way of evidence.
My lord.
By way of evidence. That's what the court says.
The material witnesses has also stated, my lord, the facts of the case is that in absence.
Material witnesses, then you will be acquitted on the ground of alibi. Where is the question of discharge when the evidence is going on?
See, only I have not.
I'll give that observation. Where is that
service
document?
Documents, my lord, at annexer 6, my lord. Annexer 6, the casual leave certificate, he has taken leave from 7/8/2022.
So these documents has to be proved by
File and
examining the
proof.
witnesses and all.
My
It
lord.
has to be proved.
My lord.
So that can only be done in the trial. That's what the trial could rightly say.
My lord.
Withdraw it, and unnecessary. Why are you inviting some observation? You may be acquitted.
My lord.
Some observation I'll give, and then it will be creating problem for you.
As your lords.
You better that you see there is no infirmity in this order.
Permitted to withdraw.
Learned counsel for the petitioner seeks to withdraw the petition to raise raise the points as has been highlighted in the present petition at the appropriate stage before the trial court. With this liberty, the petition is disposed of.
Obviously.
Yes.
Well, this is the case where offense under 326 is sought to be compounded as per a judgment of the apex court, my lords. My lords, the learned session judge says, I don't have the powers, though it can be compounded, but it can only be compounded under 482 of that is the power of the High Court, or by the Supreme Court, my lords.
Where is that order?
My lord, order is Annexure 3, page 38. Last portion, if your lordship comes to page 42.
Yes.
From the last paragraph, your lordship gets it. From the above observations made by Honorable Apex Court, it can be safely inferred that the offences which are not compoundable in nature can be compounded by invoking extraordinary power.
What are the allegations? You have burned the house.
No, my lords. There was disposal of garbage. They threw garbage in front of our house. So there was a quarrel ensued between the two parties. And that is why this case was instituted.
No,
What are the allegations?
The allegation is, my lords,
Because FIR is not filed, nothing is filed.
It is during period of conviction.
No, where is the FIR?
During appeal period, it has been settled.
No, where is the FIR?
FIR at least said.
My lords, it is described, the offense.
You have been convicted already.
Yes, but conviction is there, but still then, my lord, the apex court has compounded.
Similar case, my lord.
Similar case. It has been
326,
compounded.
that has been compounded by the apex court. Same offense, my lord, 326. During
Can a conviction be set aside by exercising 482?
Yes, my lord, that has been decided.
That has been decided.
Yes. Yes. Which paragraph?
Paragraph.
Paragraph 3 is the fact, and paragraph 18, 19, 20, my lord.
18, 19. It is now. Wait,
Ram Gopal versus state.
Ram Gopal and another versus the state of Madhya Pradesh. It is now a well crystallized axiom. The lordship gets paragraph 18. That the plenary jurisdiction of this court to impart complete justice under one.
That is 482 jurisdiction.
Ipso facto be limited.
142 jurisdiction.
Yes. No, thereafter there, or restricted by ordinary provisions. It is also noteworthy that even in the absence of an express provision akin to section 482 CRPC conferring powers on the Supreme Court to abrogate and set aside criminal proceedings, the jurisdiction exercisable under 142 of the Constitution embraces this court with copious powers to quash criminal proceedings also, so as to give complete justice in doing so, due regard.
It is also a case of 326.
This is also a case of 326.
Where is it? 326.
It does sum up and hold that as opposed to section 320 CRPC, where the court is clearly guided by the compromise between the parties in respect of offences compoundable within the statutory framework. The extraordinary power enjoined upon a high court under 482 CRPC or vested in this court under 142 of the Constitution can be invoked beyond the metes and bounds of section 320 CRPC. Nonetheless, we reiterate that such powers of wide amplitude ought to be exercised carefully in the context of quashing criminal proceedings, bearing in mind nature and this is a private dispute between the parties, and all of them have agreed.
Yes, madam. My lordship will see the nature of the grievance, my lordship. What happened, my lordship?
Have you read this judgment?
Yes, my lordship. I have also.
Yes.
I collect from the live law. My lordship, if the here it also says that in the third point, given the nature of the offence and injuries, and here the injuries is grievous, my lordship. Because in the
Therefore 326.
Yes, my lordship.
Otherwise 323 too.
Yes, my lordship. It's non-compatible and it's okay.
No, this judgment you have read
Yes,
first
yes.
paragraph. In this judgment also, he was convicted under 326.
And also he was.
Appeal at the appellate stage.
Yes, my lordship.
The court says that it can be done.
It can be done.
And they have exercised 142.
Yes.
But at the same time, they have made an observation.
Yes, my lordship.
That in 482 also it can be
yes,
done.
Yes.
What do you say about it?
My lordship.
Directly covered by it.
Yes, my lordship. I have seen that, my lordship.
And then Narendra Singh, they relied upon
Everything has
Narendra
been
Singh.
written,
Yes.
my lordship. I've seen that. But only thing is that, my lordship.
Nature of injuries incurred for which the appellants have been convicted do not appear to exhibit the mental depravity or commission of an offence of such a serious nature that quashing of which would override public interest. Here, my lords, he has suffered an injury on the hand. Nowhere have they attacked any other part. And it is a mother and son, my lords. It was their neighbor.
Let us see the finding of the.
Yes, my lords. Your lordships may see the
There is the injury. Because you have been acquitted for offence under 307.
Yes.
And only convicted
In
at
page 18, my lordship, the EMO has stated that PW7, the EMO 9, my lordship, page number 18.
18?
Yes, my lordship. Paragraph 9. Serial number 9, my lordship. In the judge.
PW7.
Yes.
The MO at DHS stated to have examined the injured Shri Behra at 9:30 AM on police requisition and found one deep incised wound of size over right arm with bleeding.
And the injury is simple in nature.
No, my lordship.
No,
one is previous.
One injury is simple, one injury is
Previous.
incised.
Correct.
The injury might have been caused by sharp and heavy object, and the injury is simple in nature.
Injury near the wrist joint
Yes.
is suspected fracture in the left forearm That injury is,
One is
Grievous.
simple and in para 10 PW8.
anyway, even if I was, I will have to issue notice.
Yes.
One
Yes.
first day I can't do it.
Yes,
I
ma'am.
issue notice, I've just, the petitioner has been convicted by the court of JMFC. That court JMFC by its judgment dated 18/9/2029 in CT bracket sessions case number 53 of 2016 for the offenses punishable under section 323,
341, 3294, 324, 326.
323, 324, 326 and 34 IPC, and has been convicted on his count for various sentences. Petitioner had filed an appeal before appellate court. Have you filed the appeal?
Yes. Yes, sir. Appeal is pending.
Appeal before which court? Session judge.
Session judge, additional session
Appeal
judge.
being criminal appeal number 19 of 2019 before the sessions court.
Additional session.
Additional session judge Tenkana, which is pending adjudication. At this stage, parties have entered into the settlement. On the basis of settlement terms, the present petition under section 482 CRPC has been filed. Mr. Kanungor, senior counsel, by relying upon the judgment of the Honorable Supreme Court reported in so and so, submits that the case of the present petitioner is squarely covered by the judgment of the Honorable Supreme Court. In the Honorable Supreme Court also quashed the conviction, set aside the conviction of offense punishable under section 326 CRPC, actually IPC, and has also observed in para 18 and 19, para 18 and 19, 2019 as under para 18. Relying upon the aforesaid judgment, he submits that the conviction and sentence recorded by the court below may be set aside on the compromise term by invoking jurisdiction of this court, inherent jurisdiction of this court. Issue notice, so and so accept notice, please the matter on 7 Saturday for final discussion.
Yes.
Final to the letter bits.
Yes. Well, it's here. I've filed a miss case. It has been, the matter has been posted to 7/3/25 for hearing of the appeal. He may not pass any order in the.
Just simply say that in view of the aforementioned, the petitioner is granted the liberty to move an application before the appellate court seeking adjournment. If such application is moved, same shall be considered favorably.
Obliged.
You ask for adjournment?
Yes, sir. 70.
79. Notice is to go on respond number 4.
Okay. Notice.
1, 2, 3 have already appeared.
Notice fresh notice be issued respondent number 4. File the request.
Already deposited the entire awarded amount before the court below. Now filed a petition for stay of disbursement.
Okay, in the learned counsel for the appellant submits that he has already deposited the award amount before the commissioner. Which commissioner? Commissioner so and so. On date, give the date, deposit date.
Deposited on 14/10/24.
Before
divisional labor commissioner cut.
In view of the same, the application, which application is that? IA number?
IA number 127 of 25, that has not.
127 of 2025 is allowed, and the disbursement of the award amount is the till next date. Yes.
I'll serve copy of
Yes.
this one.
Yes. Yes.
72.
Modification of order and extension of part-time. You have to calculate the level in the of bar association as that into a dinner and mention a district bar association on that.
Bar Association Ganjam. District Bar Association Ganjam.
Askan.
Aska. District Bar Association Aska कर दियो, extend कर दियो 25 दिन. ठीक है. Fill out. Yes.
73. Tracking report is at flag B.
Notice sufficient, sir. Notice on opposite party number 2 is sufficient. However, none appears for the opposite party in the interest of the interim order pass on 17/1/2025 shall continue. Yes.
74.
Madam, there has been 2 days delay in filing of the requisite.
Well, in item 74, Miller, I am.
You are appearing?
Yes, I am appearing for the opposite party number 2 informant. Notice is not required to go, Miller. I am filing my Okala.
Yes. So and so entered appearance for opposite party number 2 and seeks an adjournment for filing the response. This is the matter on church. Yes.
75.
But so far as the interim order is concerned, your lordship may kindly see here the 482 application has been filed for quashing of the FIR on the basis of the mediation report. There are certain terms and conditions in the mediation report. Your lordship may kindly see the mediation report that is on record. But they have not complied the mediation, the conditions in the report, that the agreed terms between the parties. Only after the terms are complied, then
what are the
yes,
what are the
then,
terms?
then 482 proceeding is triggered.
1 minute. What are the non-compliant?
Mallet, your lordship may kindly see the mediation reports. Well, I may be permitted to file an application for vacation of the interim order.
You tell me which.
Yes, Miller. Again.
Which condition?
Kindly see the total amount of rupees.
30 lakhs.
30 lakhs.
Yes.
Out of 30 lakhs, they have deposited 6 lakhs. And also that draft, although was dissolved, subsequently they paid that amount. But the first installment of condition number 3, you lordship kindly see. The first installment, it is also agreed between the party that 5 lakhs. That on or before 28/2/2025. They have not deposited.
March started.
28th April, February.
28/2/2025.
March 40.
It is also agreed between the parties that the informant will deposit the first installment rupees 5 lakhs out of rest 24,000 on or before 28/2/2025.
Subject to
they have not deposited.
1 minute. Subject to petitioner complying the terms. Terms number 3 of the mediation report dated 29/1/2025, the interim order shall continue. Yes.
But your lordship passed the order, no coercive action shall be taken. But citing that order, the petitioner number 2, he was released on bail by the court bill, although they have not complied with that order.
But see, there is a mediation now. Now I have said that subject to compliance of term number 3.
Again.
Subject to compliance of the terms number 3 of compliance report so and so, the interim order is extended till next date of hearing. Yes.
75.
Oblige.
75 minutes. The state is to say about the status because their additional affidavit, which they have filed, they have stated that they have communicated the letter of sent to the PP for final opinion. Miller. That report has not come. That
report has come. The order dated 20/11/2024 has not been complied with. Last opportunity. The matter last opportunity is granted to the state respondent to comply with the same. Leave the matter. What 2 weeks? Yes.
76.
My lord, in this case, I am for Union of India. I have already filed application as per your lordship's my appearance, my lord,
Which appearance?
along with DS.
Six, my lord. Your lordships have asked the government to take instructions in the matter. Here he is a junior soil conservation officer, my lord.
Yes, yes. Have you taken instruction?
It's very strong, my lord. The specific allegation against he has, my lord, misappropriated the subside.
No. There is no allegation against me. Perhaps he's reading something else.
I am
There
reading
is
the
absolutely
151
no allegation against me. I was never named in the FIR. I don't handle the money. My lord, the
Have
money
you
comes-
read it?
The 161 statement of one person.
Have you read it or not?
My lord.
Yes. Satyanarayana Acharya.
Okilo Meher, my lord.
Huh?
Yes, ma'am. Satyanarayana Acharya, one statement I am reading, my lord. Okilo Meher. The statement witness, my lord. The relevant part, my lord. ହିତାଧିକାରୀ ନାମରେ ଚହଳା ଖନନର ସବସିଡି ଟଙ୍କା ଆସିଲା ପରେ I am reading the relevant. ଚହଳା ଟଙ୍କା ସବସିଡି ଟଙ୍କା ଆସିଲା ପରେ କିଛି ଲୋକ ନ ପାଇବାରୁ ମୁଁ ତଥା ଗାଁର ଲୋକମାନେ ଅନ୍ୟମାନେ ବସନ୍ତ ମେହେରକୁ ଏ ସଂକ୍ରାନ୍ତରେ ପଚରା ଉଚରା କଲେ। ସେ କୌଣସି ସନ୍ତୋଷଜନକ ଉତ୍ତର ଦେଇ ନ ପାରିବାରୁ ମୁଁ ତଥା ଗ୍ରାମର ଲକ୍ଷ୍ମଣଦୀପ ଅନ୍ୟମାନେ ଏ ବାବଦରେ ବୁଝିବା ପାଇଁ ପାଟନାଗଡ଼ PIS ଆଚାର୍ଯ୍ୟ ଦିସ୍ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ମ୍ୟାଟର ବାବୁଙ୍କ ପାଖକୁ ଗଲୁ। ତାଙ୍କ ଠାରୁ ଆମ ଗାଁ ଚହଳା ଖନନ ବାବଦରେ ସବସିଡି ଟଙ୍କା ପାଇଥିବା ହିତାଧିକାରୀଙ୍କ ଲିଷ୍ଟ ମାଗିଲୁ। ଆଚାର୍ଯ୍ୟ ଆଜ୍ଞା ଜିଲ୍ଲା ଲିଷ୍ଟ ଦେଲେ। ତନ୍ମଧ୍ୟରୁ ଆମ ଗାଁର 180 ଜଣଙ୍କର ନାଁ ବାହାରିଲା। ସେଇ 180 ଜଣଙ୍କୁ ପଚରା କଲେ ପ୍ରାୟ ଲୋକ ଯଥା ଲକ୍ଷ୍ମଣଦୀପ, ରାମକୃଷ୍ଣ ଦୀପ, ମୁରଲୀ ମିର୍ଦ୍ଧା, କୁଶ ମିର୍ଦ୍ଧା, ସୁଲୋଚନା କୌଣସି।
What is the allegation? You asked for a list. He gave a
I
list.
want this subsidy amount, man.
No, what are the other evidence?
There are two.
This statement only says you have asked for a list. He has given the list. That's all.
The government money, man.
Government money doesn't mean that you have to make some allegation.
My lord, I have to obtain certain specific allegation, my lord. For that reason, my lord, I have also ascertained the specific allegation against the player. That is not in the.
You say that.
My.
And there is the second point also, my lords. I am a government servant. No sanction has been obtained.
Let him get instruction. He has not got the full instruction. The full instruction in this matter has not yet been obtained by the State Council. Therefore, he seeks an adjournment by a last opportunity. One adjournment is granted. Please the matter on session. Yes. Yes.
77, my lords, the petitioner had filed his discharge application for seeking discharge against offences under section 376(2)(n) and 506, my lords. Admittedly, the case is the petitioner and the informant were in a long-standing relationship, after which they were supposed to get married, but due to some intervening circumstances, the marriage could not be happened and the present case was registered. So now this point stands on the anvil of the dictum of the Honorable Supreme Court, passed by the Honorable former Chief Justice in a judgment wherein the promise to marriage, was it based on the condition that they will enter into a physical relationship, or the marriage had otherwise broken down, and because they had a relationship and this present case has been foisted, my lords. Now to address this court, my lords, I need a one week's time to prepare and get the judgment.
Well, in this case, I am appealing for the opposite party. First of all, 482 is not maintainable in this case because there is a separate code of 397 plus 401 of criminal division is there. Discharge with some rules on their taking child. So set aside the discharge.
What else? You had relationship.
That also, that part also frankly taking a trial level basis.
No, there is Supreme Court judgment which says that you had a relationship, long relationship. Where is the question of 376?
If that
Girl is major.
If that relationship is a dependence, that doesn't make the discharge person will be allowed.
It has to be. That's the Supreme Court judgment. What to do? For many reasons, the marriage might not have taken. Both of you are major. Why don't you settle? See, the problem is sending him to jail will take no reason.
Now, my lord.
Lords, meanwhile, my lords, may kindly see page 34 of the brief.
Threatened to the victim girl. This is.
My lords, may kindly see page 34 of the brief. While the petitioner was in jail custody, my lords, the informant had filed an application before the.
Still, she has some hope.
She is of 25 years of age, my lord. She's
She
not a
has
minor
hope
also.
because she was in relationship.
Because that is what the.
You did her, and therefore she doesn't want that you should be there in jail.
It is the.
But once you come out from the jail, again you harass.
No,
So this is the
harassment. Harassment is not there in this case, my lords. What is there?
she is emotionally involved with you.
The family members,
Why is that?
the family members of the petitioner and the informant are not getting along with it.
They only take.
That is the only issue. The petitioner is bound by his family.
That statement.
She has given the fact that she has given an affidavit before trial court
That she wants to marry.
for grant of bail. That goes to show that she is emotionally involved with you.
Lots.
He doesn't want that you should be there in jail.
Lots.
But at the same time, once you come out and you start.
Lots may send this to mediation otherwise. Let them try one more time.
See, are you still interested to marry? He is interested to marry, it appears.
Milords, I am stating without instructions from the client to send it to mediation.
Is there any scope of settlement? Ask your client.
If not, we'll come
You
back.
don't want that he should go to jail. This is very clear.
No, that time, my lord, that's why the.
Therefore, you gave an affidavit.
My lord.
Huh?
That's why the informant given the affidavit, my lord. But they're taking.
Thinking
and
that
after that, they release the bail. They are taking and harass the victim.
No. Have you filed for anything for cancellation of bail?
There is some other.
No, it's not the case. They have filed for cancellation of bail on any ground.
That's not the issue. You have been emotionally exploiting this girl.
Milords,
This is the fact.
I'll submit the 164 Milords. It is the family of the petitioner who had gone to see the family.
How much you have taken?
44.81 lakhs and another time 12 lakhs.
Then why don't you pay?
I have already paid, madam.
Show me where have you paid. Anything?
I'll
Any document where you paid?
be doing it probably. I would like to show you, but
Pay for me, then I can pass on. Merely saying I paid. You have taken the money that they paid.
that's
That's the fact. You have to take like that.
now I can also give a pendrive now wherein his old friend who is a witness in this case, he had said that why are you going to harass him? We are receiving the money. One of the witnesses.
You might have asked them to record it. That's not. You have paid, then some proof must be.
And my lord, the police has also investigated into the case and filed the.
I'll issue notice to place those things on the record.
Notice is already issued, my lord.
How much you want?
44 lakhs 81,000 through bank, not cash transaction at all. And 12 lakhs is twice account. And 44 lakh 81,000 to the public mass setting through bank. And to not inquiry, the witnesses adduce the evidence before the court that he had taken the money or not taken.
So the bank
And
transaction. But he says that he.
Not taken.
Therefore,
He said,
this can
somebody
be,
said,
this
he
can,
returned the amount to me.
Oh, those things are not.
this can be sorted out in a civil suit even. Why a criminal case? That is the sole point which is why I have approached this on the report.
But you say that civil suit, if you file, you will pay. Otherwise, you will not pay.
If they succeed, I will pay.
You've taken money, why don't you pay?
My lord. They will never succeed. I have paid it. That is what I want.
Then you show before this all.
That is what I'm saying. Show a piece of document, any document that you have paid. See, you have received the money through bank transaction. Not that cash has been paid. Bank transaction, you have taken the money. Then you show some document that you have paid, either check or anything of that sort.
I have not deceived him. The charges are under section 420. They have not made out a case either under section 420.
That's a different story. That's a different story. That we'll examine. But if you want to pay the, I'll send it to
May I
mediation.
suggest one thing? If they are, I have not taken the money, the informant taken the money. Let it appeal go to the mediation. If they taken the money.
Why don't you go
no
for
case,
mediation and finish it
if
up?
not paid, then
My lord,
ultimately your lordship.
in fact, I have paid the amount.
We.
If you have paid, show me some. Morally saying that you have paid doesn't mean that you have paid. You have to show something because through banking transaction you have taken the money.
My lord, I have taken through banking
Then
transaction.
while paying also you should have given it. Have you? Are you? Is it your case that you paid in cash? 56 lakhs.
Maybe, my lord.
Maybe.
Maybe that is
What is maybe here?
That is I want the examination of the witnesses. That is the sole reason.
Then face the trial. Face the trial and keep on examining.
This is not a case under 420, my lord.
That you can't be dishonest. You have to.
I am not dishonest, my lord.
Wait, well. Yes, let us see. Let us see the allegation then. I'll see whether cognizance order can be passed.
I have depended on 4 judgments of this on the Supreme Court, my lord. May I cite the judgments?
Yes.
And if your lordship wants, I'll be satisfying whether what amount he has paid through bank or what amount he has paid through.
That's what I'm asking you. If you can show something.
But my lord, I cannot satisfy entirely to your lordship, my lord, in that way. Since some amount has gone, I'm an employee, my lord. I cannot give all the cases to my account.
So through anybody's other's account you have given?
My wife's account might have been given or anybody's account have been.
Show me those things. Any money transferred to his account through your wife or through your friend or through someone. You show me something. What do you say?
I will take instruction. He has to give.
I'll send it to mediation. You sort it out. If you paid, tell the mediator that I have paid this much, and sort it out.
There is no mediator, my lord. It is between him and me.
High Court mediation.
I'm sending to High Court mediation. I'm sending to, because there is now the statute has been is there in the place. Mediation act. So therefore you should go. I don't. The council.
That will come after 3 weeks, my lord. 3 weeks or 1 month.
Minute. Council for the petitioner. Submit that the scope of the dispute is arising out of a money transaction between his client and the complainant, and there is a scope of out of court settlement. The council appearing for opposite party is also of the same view. Therefore, the matter may be referred to mediation center, High Court mediation center, to explore the possibility of a settlement, and awaiting mediation report. We'll see matter also. Yes, one participate. Yes.
Yes, he put it to.
Give a date. 3 weeks. 3 weeks. Yes.
Because he is there in Baroda, he may have to come here.
3 weeks. Yes.
Item 80. Submitting in your favor. It is difficult for 3 weeks.
3 weeks. After 3 weeks or 4 weeks.
Okay. Item 80.
70?
79.
79
Interim order also the charge trial has completed.
This is very unfair. See the lawyers coming and without informing. Who has been mentioned?
All the witnesses have been examined. Whether is passing of cognizance just down.
For petitioner. You are appearing for?
And number 2 informant.
And you are appearing for?
Next item.
Next item.
See, this is very unfortunate. Your brothers are doing that.
Second of the trial, challenging cognizance.
And you should have opposed. You also didn't oppose. Nobody was there. Please tomorrow, Saturday.
Yes.
Tomorrow.
Yeah.
Day after. Please day after. I'll vacate the stay.
Yes.
What is this?
So suppressing the fact about cognizance has been taken.
If you come and mention, at least you inform the other side. This is minimum. Yes.
Item 80. Next week, man. Item 80.
lot of time they have taken.
No,
His
no.
lordship will have taken. I have nothing to say. This is the
Trial has
case.
continued, case posted to 18/3. In the trial.
1 minute. This is a case, Rashmi, remember the students, they have, ABB students are agitating before this board.
Oh, that one.
That case. And that case, my lord, last occasion asked me two things. One, whether any evidence is made out against the accused persons who are before my lord. Number two, whether any acquittal is made or not. In the all two respect, I filed the affidavit, Rashmi, flag B and flag C, Rashmi. Deputation copy I have given. And also file an affidavit that one minor has already been acquitted. But what remained, my lord? The president himself deposed that, I don't know. The prosecution council, the state council can confirm itself. Only because of
I'll put it in the next week, but why are you after these young people?
No, man, trial is going on, minor, case is posted to 18/3.
They were.
Case will be posted because my lord has given liberty. Case will be posted there. If you want that, you can also complete the evidence. That's why it was posted.
These young students were agitating for some cause. For that unnecessary, you can't spoil their career like this.
When out of one second matter, he has got a section officer post in
Let it be. Let's take senior.
Unnecessary. In the student life, so many things happen.
May I pray one thing, my lord?
Are they criminals? All of them are students. You don't treat them like criminals and don't convert them to criminals.
May I pray one thing, my lord?
Yes.
Lordship may close it. I will file my written note submission. My lord, senior may file the written note submission because a lot of occasions the same thing repeated.
So what do you want exactly? What do you
Next
want?
week. Taken up.
The next week is all right, but what exactly you want in this case? You want them to be convicted and become criminals? All of them are students.
No, man, all are not students.
See, few of them are working, few are minors. And the juveniles, those who you have booked, all of them are acquitted. See the allegation. Let us see the allegation. What are the allegations? See the allegation. Read it out. Allegation.
We have tried to trespass, my lord, the office.
Office of?
Board office.
Board office. They were giving a dharna and all these things.
My lord, what happened? They have question paper has been disclosed.
Furniture.
Broken some furniture.
Broken the door and
Furniture and
furniture
window
and
staff vehicle.
These things are happening in the parliament also. What is this? I'm giving, I'll list it on 11th and I'll quash it. Don't see these young people, you can't spoil their life like this.
ଚାକିରିଟା ଜଏନ୍ କଲା ପରେ ତାକୁ ବଡ ହଇରାଣ କରୁଛନ୍ତି ସେଇଥିପାଇଁ ସିଏ ତାକୁ କହୁଛନ୍ତି allegedly because of this course is pending they are not taking
But
it.
he has some personal problem. I'll put it 11th.
Senior asking me time.
11th, 12th. 11th, 12th.
But let me give a last chance. Last chance to.
Last chance, and that day you come with written note and give it.
Yes, yes.
And I'll pass.
I'll give the written note.
Yes, sir. Are you saying something? What do you? Interim will continue. Interim will continue.
Your lordship may allow 2 minutes. One more time, your lordship.
Let the mediation process go on. If the mediation will go on.
I will be out of session for 20 days.
It's all right. Mediation, you need not participate. Mediation immediately doesn't happen. It takes months together. Thereafter, after 4 weeks.
Probably 1 or 2 sittings might take place.
Yes, then I'll adjourn it. Don't worry. Yes.
Well, may I pray one thing? Because my land senior is coming, it's very difficulty. 11th, 3 p.m. or 3:30, let's like this. Can we end last chance?
Yes, yes. 11th. 12th, 12th,
yes. 12th, yes.
Yes.
12th ବେଳେ 12th 12 ତାରିଖରେ
3:30.
12 ତାରିଖ 3ଟା ଓକେ ଓ ବୋଲେ yes
yes
petitioner challenging the order of criminal division number 2424 which has been dismissed as not maintainable.
in a one-side NI, the recall petition has been filed. That has been allowed. Challenging same, the petitioner approached the session judge in a revision case. That has been rejected. Challenging this revision petition, the petition before the summary.
Let us see the revision order.
Lords.
Yes,
Revision petition, annexure 3, page 44, my lord.
yes.
The examine was the CW2 was the examine and cross-examine. But in the deleted stage, the allegorical petition.
So which part you
Lodged. And this is base 26, the ground, para 4.
Yes.
Telangana Court Kilo has not specifically given any findings in his order to recall the CW2 for further cross-examination. But the finding of the court is due to lapses of the complainant, the case will be lingering and the accused is suffering. But on the other hand, allow the petition filed by the complainant, hence the order is liable to be suppressed.
Yes. Who is appealing for the other side? Notice was issued. This week, check. Until appearance. Nobody is appearing for opposite party. None appears for opposite party despite service. In the interest of the seizure agency also, interim order dated there. Interim order is there?
Lost. Lost, lies there.
Where is the interim order? Just check it out. You're talking about this, no? Pavitra Sahu.
Yes, sir.
Service he. Pradeep Pradhan. In the interest of the seizure, okay. Yes.
83.
Yes. Written note of it.
No, if my learned friend has finished, I can start.
He has
If you have
finished.
anything to add, you can.
He has finished already.
He's finished.
Yes.
Yes, my lord,
In the rejoinder, you are supposed to say something.
Yeah, my lord, since that doubt has arisen,
Yes.
your lordship, I want to clarify that. My lord, kindly look at, I have given a note. Of course, not note to understand, my lord, what the, kindly look at, but the issue involved here is simple. That if a person is acquitted or discharged from a scheduled offense, whether a PMLA proceeding can be maintained, whether section 3
To that extent, he has already considered to the fact that insofar as the petition number 1 is concerned, he doesn't have any problem.
Because the reason I'll tell you why he is considered. He is considered because your lordship have discharged. There are 2 accused. One is dead. Both the accused were discharged. But why both the accused were implicated first? They are implicated, my lord. What has happened in this case? Can I, my lord, if your lordship don't mind, can I show the provisions so that your lordship will look at the provision? No, I have quoted those provisions.
Yes. Yes.
This is the issue. Kindly look at what is, my lord, money laundering. That is section 2(1)(p) speaks of money laundering.
No copy has been submitted.
I think give a copy. Sorry. Look at section 3. What my learned friend is saying, he's assuming that there is something which is in existence.
Yes, section 3. Yes.
Section 3. offense of money laundering, whoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process and or activity. Kindly mark the word process or activity connected with the proceed of crime, including its concealment, possession, acquisition, or use, projecting or claiming it as untainted property, shall be guilty of the offense of money laundering. Isn't it? So the first thing is
process and activity. Participation in the process or activity
in relation to a proceed of crime.
Correct.
If there is a proceed of crime, yes, they come in. If there is no proceed of crime, Section 3 doesn't come in.
Yes.
Because proceed of crime is the sole ingredient, very core ingredient of Section 3.
Yes.
And since it is a penal provision, it has to be construed strictly.
Yes.
Now, the explanation which he has read, my lord, Lord, it is by an amendment in 2019. This was challenged. 2019. This came up. But this was challenged. Even in Vijay, I will read that portion, my lord, where it is said it is nothing but a clarification. It doesn't make any...
The explanation is clarification.
Clarificatory,
Yes.
that is what the Supreme... My lord, that is source from the first wording. It is clarificatory. Now, proceed of crime. Look at the...
It starts with the sentence for removal of doubt.
Correct, correct.
If the statute, there is no doubt.
Therefore,
there is a question of
there is no doubt, my lord. Therefore, you have to determine, my lordship, whether there is any proceed of crime for them to step in under Section 3.
Yes.
Now, look at what is proceed of crime next, my lord, paragraph.
Yes. Section 2, 1.
Yes.
Yes.
Proceed of crime means property derived or obtained. These are the two words, which is completely different from Section 3. Section 3, process and activity. Here it is
derived or obtained.
Derived or obtained directly or indirectly by any person as a result of criminal activity in relation to the schedule offense or the value of such property, or where such property is taken or held outside the country, then property equivalent to the value of held in the country or abroad.
Yes.
Again, removal out. But therefore, you can't presume after acquittal, you can't presume that my respectful, you can't presume there is a proceed of crime. Because it must be relatable to the criminal activity.
The entire basis goes.
But therefore, the first stage is there must be a criminal activity of a scheduled offense. The second activity should be there must be a property derived out of that scheduled offense. If this exists, this may or may not exist. But if this exists, proceed of crime, then Section 3 step in. That's a simple answer. These are all, that is why I gave a chart.
Yes.
You must have criminal activity, then proceed of crime, then. If the criminal activity goes, proceed of crime doesn't exist.
So therefore, Section 3 will
not apply.
Because it is the process and activity.
That is process activity. The proceed of crime must be derived out of a criminal activity.
Yes.
Otherwise not. Then property definition, my lord, any type of property, schedule offense. Now, my lord, I must read to your lordship. Lord, in any other, because there has to be a strict interpretation, any other interpretation will amount to rewriting the definition of proceed of crime.
Yes.
And therefore, my lord, when you are discharged, if you say, no, I assume that the proceed of crime exists, and then proceed, it will be paradoxical. Kindly look at now the judgment of Vijay Madan Lal. Relevant paragraph I have quoted here. Entire judgment I have given to your lordships.
Yes.
If any other paragraph it is relevant for your lordship, I consider, I may be excused for that.
Yes.
Lord, kindly look at para 29 of that judgment only. I have given the para 29 page 335 of the paper book I submitted.
It is written.
Yes. But can I read it, my lord, if your lordship don't mind?
Yes.
Coming to the next relevant definition is the expression money laundering, it has the meaning assigned to it in section 3 PMLA. We would dilate on this aspect while dealing with the purport of section 3 PMLA little later. Para 30.
Yes.
The other relevant definition is proceed of crime in section 2(1)(u) of 2002. This definition is common to all action under the Act, namely attachment, adjudication, and confiscation being civil in nature, as well as the prosecution or criminal action. The original provision prior to the Amendment of Finance Act took within its sweep any property mentioned in section 2(1) PMLA, derived or obtained directly or indirectly by any person as a result of criminal activity relating to a civil offense mentioned in section 2(1)(y), read with schedule of the Act, or any value of the property. Then, my lord, look at next. The thrust of the original provision itself.
That's what you argued.
Yeah, that's right.
Yes.
Is to indicate that any property is derived or obtained directly or indirectly as a result of the criminal activity concerning the schedule offense, the same be regarded as a proceed of crime. In other words, property in whatever form mentioned in section 2(1)(5) or is or can be linked to criminal activity relating to relatable to schedule offense must be regarded as proceed of crime for the purpose of 2002 Act. It must follow that the explanation inserted into one is merely clarificatory and restatement of position. Now look at para 31. The proceed of crime being the core ingredient constituting the offense of money laundering. That expression needs to be construed strictly. In that, all the properties recovered attached by the investigating agency in connection with the criminal activity relating to the schedule offense under general law cannot be regarded as a proceed of crime. There may be cases where the property involved in the commission of schedule offense attached by the investigating agency dealing with that offense cannot be wholly or partly regarded as proceed of crime within the meaning of section 2(1)(u) of the 2002 Act, so long as whole and some portion of the property has been derived or obtained by any person as a result of criminal activity relating to the stated schedule offense. To be proceed of crime, therefore, the property must be derived or obtained directly or indirectly as a result of criminal activity relating to the schedule offense. To put it differently, the vehicle used in the commission of schedule offense may be attached as property of the case crime concerned. It may still not be proceed of crime within the meaning of
same
section.
thing which you have argued, it is elaborated.
That is what is
and in para 33 also the same thing.
Para 33
derived and obtained.
But para 33 is very important.
Yes.
Because this is what is subsequently followed by Supreme Court itself saying no. Once the schedule offense goes, the proceed of crime goes.
Yes.
Para 3 tersely means concisely put it is only property which is derived or obtained directly as a result of criminality relating to schedule offense can be regarded as proceed of crime. The authority under the 2002 cannot reach to action against any person for money laundering as on the assumption that the property recorded by them must be proceed of crime. And the schedule offense has been committed unless the same is registered with the jurisdictional police or pending inquiry by way of complaint before the competent forum. The expression derived or obtained is indicative of criminal activity relating to the schedule offense already accomplished. Similarly, the event of the person in the criminal activity relating to schedule offense is finally absolved by a court of competent jurisdiction owing to an order of discharge, acquittal, because of quashing of criminal case against him. There cannot be no action for money laundering against such person, by kindly look at the mark, or person claiming through him in relation to the property.
Yeah.
Any one of them, either this or any one of them, linked to the stated schedule offense. This interpretation alone can be countenanced on the basis of the provisions of 2002 Act, in particular 2(1)(u) read with section 3. Taking any other view would be rewriting this provision and disregarding the express language of the definition clause proceed of crime as it operates now. Now look at 42, my lord. He has quoted in his counter, therefore I have not.
Yes.
The same thing.
43.
43 here.
Last 3-4 lines. Relevant date.
Yes.
Date of a person.
Well, kindly look at 42 last, 42 last sentence, para 42 last sentence. This offense otherwise nothing to do with criminal activity in relation to a scheduled offense.
Yes.
Except proceed of crime derived from, they are speaking of section 3.
They say it is an independent offense altogether.
Except the proceed of crime.
Yes.
Now, my lord, kindly look at the page 52.
Yes.
This is what, para 52. The next question, whether the offense under section 3 is a standalone offense. Indeed, it is dependent on the wrongful and illegal gain of the property which constitute the offense of money laundering. This property must qualify the definition of proceed of crime under section 21U of 2002 Act. As observed earlier, all or whole crime property linked to the scheduled offense need not be regarded as proceed of crime, but all properties qualifying the definition of proceed of crime under section 21U will necessarily crime properties. Indeed, in the event of acquittal of the person concerned or being absolved of the allegation of criminality relating to scheduled offense, and if it is established in the court of the law that the crime party in the case concerned has been rightfully owned and possessed by such property, by no stage it can be termed as crime property, and ex consequency proceed of crime within the meaning of section 21U as is to today. On the other hand, in the trial connection with the scheduled offense, the court would be obliged to direct return of such property as belonged to him. It would be then paradoxical to still regard such property as a proceed of crime despite the adjudication or by the court of competent jurisdiction. It is well within the jurisdiction of the court concerned, trying the scheduled offense to pronounce in the matter. Para 53. Be it noticed that the authority of the authorized officer under section 202 to prosecute any offense for offense of money laundering gets triggers only if there exists proceed of crime within section 21U of 2002 Act. And further, it is involved any process or activity. Not even in a case existence of undisclosed income, irrespective of its volume, the definition of proceed of crime under section 2 will be accepted.
I got it.
My lord, now, my lord, kindly look at para 54. Even though 2002 is a complete code in it is only in respect of matters connected with the offense of money laundering, and for that existence of proceed of crime within the meaning of section 21U appeal is essential. Absence of existence of proceed of crime, as aforesaid, the authority on the 2002 cannot step in and initiate prosecution.
Yes.
Now, conclusion is same, my lord. The conclusion is once goes. Now, what is our case, my lord? My lord, kindly look at the case. I have quoted those case, my lord. My lord, kindly look at the conclusion, last paragraph, last sentence.
Yes.
Last sentence. If the person is finally discharged, acquitted of the scheduled offense or criminal case against him is quashed by the court of competent jurisdiction, there cannot be any offense of no offense of money laundering against him or anyone claiming such property being property linked to stated scheduled offense through him.
You are emphasizing the last three.
Correct, my lord. Anybody.
Anyone.
Anyone. Because the question proceed of crime goes.
Proceed crime goes.
Now kindly look at what is their case. Because
your proposition is if there are three accused, one of the accused, if he is acquitted on the merits,
yes,
then the in the realm of proceeds of crime, the entire property goes. So therefore, the other people, those who have not acquitted, against them also PML doesn't lie. That's what you are saying.
Yes, no, I'm sorry. Let us not mix up those. One is schedule offense. One is PML.
I am talking about schedule offense.
Schedule offense, if there are 3 accused.
Schedule offense, one accused goes.
No, other 2 doesn't go, madam.
No, schedule offense doesn't go. But
Nah,
PMLA
that's
goes
the
because
schedule-
it's section 3 goes.
Section
That's
3.
what you are saying.
That's right. Madam,
Proceeds of crime goes.
But if there are 2 accused are there in respect of schedule offense,
Let them face it. That's a different story.
The proceed of crime section 3 doesn't go. If from them is there,
If there is a finding that there is no proceeds of crime,
Madam, can you look at the case?
that is what you are.
That is what I'm saying.
Yes.
There are 2 accused in the schedule offense in this case.
One died, one acquitted.
One acquitted. No, both are acquitted. After acquittal, one died.
After both of them.
There are
both the partners
There
go.
are, of course, government officers. Forget about the government because there is no PML against the government officers.
Yes.
Now, their case is, if your lordship look at the complaint itself, I quoted those paragraphs. The case is, Sirajuddin mine owner illegally excavated. Illegally did this. Sirajuddin mines illegally, I quoted those paragraphs. At next page, facts of the case. I quoted this page.
Yes.
But who are the accused?
Partners.
The managing partners, not all partners. The managing partners who are responsible for mining. Because as your lordships note, a company or a firm, they are juristic personnel.
Juristic person, they are not.
They work through human agency. So therefore, the vigilance department said, Sirajuddin Mines has done this. Sirajuddin Mines has done this. But who are the person who are responsible for doing this? These are the 2 managing partner and the other officer. The other partner is also a managing partner in respect of another mines. 2 mines, Joda and one is iron.
Yes, I understood.
If your lordship look at, just skip over, turn to the 3 pages, page 22. I've quoted those.
Yes.
Look at lessee Sirajuddin Company, your lordship got it?
Yes, I got it.
Has illegally produced iron ore in excess of the approved quantity mentioned in the mining plan. The lessee Sirajuddin Mines has illegally excavated iron one so and so outside the broken pillars. The lessee so and so illegally excavated pit so and so iron one. Then the lessee Sirajuddin has illegally. Now look at the charge sheet.
Yes.
Charge was filed before the Sajib government officer Muzaffar Rahman, partner in charge, management of Guru Manganese ore of Sirajuddin offense under section so and so. He is the partner in charge. The charge against the government officer have shown undue favor as a result of proceeding. Then 7. Investigation of the inventing. Investigation under PML was initiated ED under so and so against Sirajuddin for alleged commission offense under the on affair dated so and so, subsequent final charge number so and so, FIR number so and so, subsequent final charge sheet number related to Guruda Manganese ore and Badal of Sirajuddin Company as aforesaid charge is related to the commission of schedule offense under so and so. Sirajuddin was not made accused in the schedule offense. 2 partners, they were the partners doing it. Now look at the conclusion under that and the complaint. In view of above, it was revealed Mr. Sirajuddin has acquired proceed of crime out of the commission of schedule offense under PML and project the same as undated investigation so and so. From the investigation, it is clearly established Sirajuddin represented by so and so were responsible for the conduct of the business of the firm, committed the offense of money laundering. Yes. So therefore, if these 2 are there, now the High Court has quashed it. Kindly look at the High Court quashing. One paragraph I will read, my lord.
Yes.
Look at the main paper book. Because he said, my learned friend said, oh, these are all on a technical ground he has been.
Yes, it's 63.
63, my lord, kindly took the other 63 same because
he has died.
He has died. The other one is at page
122.
120, yes.
122.
122.
isn't it?
It starts from 92.
Sorry, 92, right, you are right, 92.
92 it starts.
Here both
Well-
the partners are petitioner. The person died and the present petition number 1.
Yes.
Now, my lord, kindly turn to page 104.
Yeah.
Para 5.
Yes.
Besides the contention as above, the petitioner have also relied upon certain subsequent events to contend that launching of the present prosecution is not sustainable on law. It is averred by him that the multidisciplinary committee constituted by the state government on this, comprising Director of Mines, Odisha representative of Director of Vigilance, representative of the Principal Secretary Forest and Environment Department, Regional Controller of Mines, Indian Bureau of Mines, Director of re-examined the vigilance cases in relation to the mining leases, including the present case, by holding several meetings in the year 2017. It has been observed inter alia by the said committee that the allegation made by the vigilance by charge sheet in the present case are not correct. The petitioner further submit that in the aftermath of the judgment on so-and-so, in the common case, the special investigation team, Black Money, observed that a fresh look may be given to the multidisciplinary committee and the enforcement directorate should be part of the said committee for taking a fresh decision. In the light of the judgment of the Apex Court, the vigilance case in relation to the mining lease were revisited.
Who suffered the common cause consequences?
Well,
Sirajuddin?
though were environmental violation, they impose penalty.
No, who suffered that consequence?
But there are mine owners who have suffered.
Now, what about you in your case?
No, we didn't suffer. We didn't suffer because we were asked to pay penalty for the environment. We paid that. Some 600 or 700 crores.
Okay.
But kindly look at vigilance case in relation to mining lease were revisited by the committee, and the same committee by the subsequent report dated reiterated his views given earlier. The committee has found the allegation made by the vigilance case is to be based on misconception, incorrect facts and figures. It is ultimately submitted that the petitioner, in view of the effort, nothing survives. And this report, government report, was looked into, accepted, apart from other grounds.
And the secretary.
Was. But this is the fact, and that is why neither vigilance department went to the Supreme Court nor ED went to Supreme Court. Because the first thing Supreme Court would have, you have looked into it. You have given the report. They didn't. 2 years, 2.5 years have passed. And now, my lord, what has happened is, in these circumstances, if two partners, their finding is this.
At that point in time, there were only two partners.
Two partners. No, there are other partners who were not grouped in schedule of offense.
Okay.
They are not. Till today, no partner has been involved in schedule offense. So the proceed of crime which they allege in the complaint, these two partners operate the mines illegally, seriously illegally, and to the disadvantage government, they got the money.
Yes, I understand.
Your Lordship, that is why, my Lord, I have, and they have relied upon Devendra Padre, that on document can be relied
Yes,
upon.
Mr. Agarwal.
Now, my Lord, one more thing.
Yes.
One more thing. Now, kindly look at page 130.
130?
Yes.
Yes. Yes.
This is again, my Lord, one of the mine owner. Learned senior counsel referred to the judgment delivered by this court in so and so, wherein consequence failure of the prosecution has been provided in following terms. Then it is submitted in the present prosecution in relation to schedule of offense proceedings under the prevention of money is based, have already been come to end, and the petitioner have been discharged on so and so by order dated by High Court in Kerala. The London Council submit that in a given state of facts, the law declared by this court, there cannot be prosecution for.
Yes, that's.
My Lord, kindly record. One is one more serious thing I must present to your Lordship. This judgment of the High Court Well, this judgment of the High Court where the schedule offence were quashed. That is of 23/9/22. 22. Now a supplementary complaint has been produced before.
I know the other sons of the
Other
dead partner has been.
No, other two partners have been brought in. And if your lordships look at the supplementary in 23, and that supplementary complaint, if your lordship look at, relied upon these two affairs, which has been quashed.
Where is that?
Lord, look, they have filed the supplementary on the hand, because I tell you, lordship, the person who filed the affidavit, counter affidavit, he never annexed this complaint. The prosecutor, London prosecutor, thought it to give it to her lordship court.
I have not given it.
Who has given it?
I have not given it supplementary. I just handed over, my lords, that order sheet.
That
there are other. I have not handed over.
Okay. Then look at the
That's all right.
complaint.
All right.
Look at the complaint.
Fact remains, place it on record then.
Well, look at the complaint.
I only handed over to my lord that order sheet. There are other.
If this is again a 44 complaint.
Yes, 44
I
complaint.
submitted, there are other accused persons.
Yes.
Whoever, my lord, has filed this, I must tell your lordships, in the language that is Sudhata Manor, fairness demand and judicial decorum dictates that this fact ought to have been noticed or brought to the notice of the court.
In the supplementary complaint, have you said that the other partners have been acquitted?
No, other partners, there is no, the other parties now, cognizance has been taken under PMLA. Schedule offence are not there against them. And on the basis of the same two affairs.
They have not disclosed it, that High Court has already quashed.
That's what
They have not disclosed.
That's what I'm asking.
They have not disclosed. On the basis of the cognizance has been taken. I reserve my right to challenge the same.
Because this supplementary was filed
on 23.
Okay, in 23.
Yes. This is a serious issue.
4/9/2023.
Yes. They don't disclose in the complaint that the charge of affair has been quashed by this court.
Yes, Mr. Agrawal, just see.
First of all, my lord.
The propriety demanded that you should have.
Proprietary also demands now petitioner should have filed this along with the CRLMC application. Petitioner himself suppressed it. And whether they have intimated to me that such a proceeding schedule offence has been quashed, where is the question of my knowledge?
No, you are not the party.
No, I am not the party there.
No, I am not.
Where is the question?
They only recognize state. They only recognize state. An accused only recognizes state.
And they should have filed
this branch, that branch makes no difference.
That respect permission with permission. With that respect.
Yes.
They should have filed it along with their.
Well, I have not challenged.
Anyway, that's
I have not challenged.
That has been filed that there is no dispute. Allegations were made that I have suppressed. Rather, they have suppressed. They should have filed along with their 482 application.
My lord,
this is the fact.
Okay, this is neither here nor there.
My lord, I tell your lordship, yes, I didn't file this because I have not challenged the cognizance taken in pursuant to this complaint.
You have a right to do that. You will.
In the subsequent, that's right. And now he filed the cognizance taken here in this complaint. He filed it. Therefore, I call for the complaint. I filed. This is what
I have not filed complaint. I just filed the order sheet to show that there are
the order sheet.
Okay.
Only two.
Okay. Are you interested to add something?
Milord, first of admittedly, the schedule FIR has been registered under schedule offence against number of persons. Only against 2 persons FIR has been quashed. So it is, your lordship kindly see paragraph 52 of that Vijay Madanla judgment again.
Para 50?
Para 52.
Yes.
At internal page 296.
Yes. Read it. He has given the extract.
Yes, I have given that. 52.
52.
Para 52.
Yes. The next question is whether the offence.
Your lordship, kindly to page 296, last 3 lines.
Yes.
And if it is established in the court of law that the crime property in the concerned case has been rightly owned and possessed by, where is the finding below? That the proceeds of the money generated by the accused persons and the company is not the proceeds, kept by them as a rightful owner. Where is the finding below?
Yes.
Such a property of, if the court gives a finding while acquitting in the schedule offense that these properties are not proceeds of crime, then only PMLA proceeding. And as I pointed out on the last date below, there are two types of actions. I have cited also judgment below. Suppose I committed a schedule offense. I parked that money with X. Can that X be not included as accused?
Yes, of course. You can.
Then your lordship kindly again see.
Are you equating that X with Sirajuddin and company?
My lord, Sirajuddin company is the main accused. At that time, 2% of 2 mining lease, 2 persons were managing. So they were made. After death of first person, the other accused who were added in supplemental, they are the managing part of the proceeds of crime gone in their hands.
Okay.
Regarding that accused number 2, I have not, my senior submitter, I have not considered. I leave it to court. Yes.
Yes.
I have never considered that was the proceeding against 2.
Yes.
Your lordship will understand my creditor. Your lordship again, kindly see now, paragraph 93.
Yes.
Once they must, burden is on them to show that this property acquired by the Sirajuddin mine is not proceeds of time under section 24 of PMLA. Paragraph 93, my lord.
93. You also do in this similar fashion, huh? Which paragraph?
Yes, yes.
Similar
Yes.
fashion, so that is easier.
Same, my lord.
Yes. Because it's so big a judgment, very difficult.
Yeah, yes. Same page. At page 374.
374.
Internal page. Okay. Your running page may be different. Internal page is 374.
Yes.
Para 93.
Yes.
At page 374. Internal page is 458.
458, huh?
Sorry, internal page 37, running page 458.
Running page 458.
Yes, no.
Yes. Yes.
Be that as it may, this section 24 deals with 2 situations. Section 24 is on burden of proof. The first part concerns the person charged with the offense of money laundering under section 3. The second part, clause B, concerns any other person. Taking the second part first, such other person would obviously mean a person not charged with the offense of money laundering under section 3 of 2002 Act. The two parts in one sense are mutually exclusive. If a person is charged with the offense of money laundering under section 3 of the 2002 Act, owing to a complaint filed by the authority authorized before the special court, clause A would trigger in. As regards the second category, clause B of person, the expression used in is may presume, whereas qua the first category covered under clause A, the expression used is shall. Unless the contrary is proved, presume. In this category, if a charge is already framed against the person for having committed the offense of money laundering, it would suppose that the court framing the charge against him was prima facie convinced. Here, my lord, cognizance has been taken. Accused persons are not appearing before the special court going on time, application after application. This type of application for twice filed, twice withdrawn. Before my lords is the 3rd time. And till date, the accused has not appeared before the special court in spite of number of adjournments since 2020 and after supplementary 23. They are going on taking time. Even in, as per the Tarsam law judgment also, they have not appeared. So framing of charge does not arise at all. And the prosecution is not at fault.
Yes.
Matter had disclosed grave suspicion against such person. In such a case, once the issue of admissibility of material supporting the factum of grave suspicion about the involvement of the person in commission of crime under the 2002 Act is accepted in law, the burden must shift on the person concerned to dispel the suspicion. Here cognizance has been taken, my lord. So now burden is on them to show that these
They have to
people-
dispel it. That's what.
Yes.
Yes.
It would then not be a case of reversal burden of proof as such, but one of shifting of burden on him to show. Now your lordship may skip over. Your lordship kindly see paragraph 96.
96.
At running page 467.
Yes.
Internal page 383.
Yes. I'm there.
Suffice it to observe that the change affected in section 24 of the 2002 Act is outcome of the mandate of international convention and recommendations made in that regard. Further, keeping in mind the legislative scheme and the purpose and objects sought to be achieved by the 2002 Act, coupled with the fact that the person charged or any other person involved in money laundering would get opportunity to disclose information and evidence to rebut the legal presumption in respect of fact within his personal knowledge during the proceeding before the authority or the special court. So they have to prove, my lord, during trial, no, these property are not the proceeds of crime. These are legally earned by the company. So this is not the stage to quash the entire proceeding. And there are other accused persons are also there.
Yes.
Can be, it has reasonable nexus with the purpose and object sought to be achieved by the 2002 Act. In any case, it cannot be perceived as manifestly arbitrary as is sought to be as before us. Be that as it may, we may now proceed to then 97. Your lordship.
Then you rely upon certain paragraph, Vijay Madannath. You prepare a note and
I'll give me, lord.
Yes.
And my humble submission, my lord, it's a separate and independent offense. Schedule offense has not been quashed entirely. If schedule offense entirely could have been quashed, then the things could have been different.
You have to place this also in record. The supplementary.
I'll give and I'll give also a short one paragraph regarding that.
Yes, and a written note within 2 weeks. Written note with judgment result. You also please file a note. And this is in the same fashion, Mr. Agarwal, the same fashion you give it, so that he is relying upon certain judgment, certain paragraph.
Whatever paragraph he wants to rely, and he must also indicate, because Supreme Court every heading, section 3, section 5, pale. So then what context they have said, your lordship should be aware.
No, if that paragraph is there, I'll refer to.
Correct. Your lordship may refer.
I'll read that paragraph and go there.
Correct.
I know, I've seen it.
I'll read paragraph number, page number, and I'll also
and I'll not
word to word I'll post
I'll
that
just
also.
see your paragraph and look into the book.
Yes.
Correct, your lordship.
I'll just place that entire paragraph also, I'll put there.
Right. Please do that within a week.
No, I don't think after the High Court judgment was saying it depending upon the state government report where it is a party that I think.
One line below on that.
Yeah.
One line I'll submit.
Yes, that's
Lord.
right.
Here below, vigilance case is not only on the basis of illegal mining. Here, if your lordship looks to my complaint, and here all theft allegation is also there, 379 is also there. So question of whether the committee they have paid penalty environment, that's not the question. That's a completely different thing.
Yes.
Okay.
Argument heard. Concluded. Argument concluded. Parties are directed to file written note of submission within 2 weeks.
Can it be 3 weeks?
3 weeks. 3 weeks, judgment reserve.
Because 2 weeks I'm going.
Yes, 3 weeks.
After the 1 week, I'll come and prepare.
Yes.
I'll give it. No problem.
3 weeks and
Much of that.
okay.
Can we pray one thing, my lord? The interim order was there, your lordship directed to pray for an adjournment, move for an adjournment application. Lordship may pass an order of state will.
No, stay I will not. First day I will
Then the
not.
interim order will come.
No, I'll dispose it up. I'll make it 1 week.
Yes. No.
I'll dispose it up.
Because
So therefore,
2 days
he has some problem. Let it be. After the argument is concluded, interim order variation is not possible. It is not required.
I am not paying for interim order.
I know you.
I am also not there. I am also not there.
He doesn't act-
No, I was not there.
He was trying his luck. That's all.
I am not there SPP block. I
Yes.
am not there.
But in other case, you are
Yeah.
there.
Other case maybe. Obliged.
My lordship, item 84, your lordship has directed to obtain the injury report because 307 is there. I need some more time, my lordship.
Acha, injury report, let him get.
They want to do the settlement.
Let him get injury report. Huh? Injury report, please. Yes.
85.
85 and 86. I've had your lordship exhaustive.
Every day it is at the end of the day you are exhausted only.
Next week.
You don't want to take chance. In
Chances is very, because your lordship has already been observed.
I'll put it.
No chemical adjudication.
I'll put it next week sometime. Huh? Next week, when do you want?
Next week.
Next week देखी देगी 13 तारीख को.
What about
17, 18.
85 and 86? Both of it.
85, 86.
And interim order is there in the
Now entry more to country.
Home.
Yes.
87.
May I please, Your Lordship?
Morning you mentioned.
Yes, my lord.
Consciously I reached here.
Yes. My lord, this is a case, my lord, that release of interim passport, interim release of my passport, my lord.
Who is opposing?
My lord, CBI. They have also filed a counter. My lord, actually, my lord, by virtue of your lordship's order, in the last, in the July, there was a order, I came before your lordship. Your lordship allowed me to go for 2 months. After completing my journey, I surrendered my passport in time. That is in November 4th November, I surrender. Then again, I required, my lord, for because there's a March month, and also there was an exhibition, which has, of course, is already over. Because of this delay, I sent one of my person. I could not personally attend, but there are some business contracts there over US and UK because of my
Let's
company.
see what are the objection.
So objection is
Generally
that
this is allowed, but if there is some serious objection.
no, objection is that this is a offense under section cheat fund,
objection
and he has already gone and he has already paid. And this is a case where he has to appear that, but trial has not started, my lord, because till date, police paper is not ready. There are 18 accused persons, 237 witnesses, 1100 documents. Till date, nothing has been done.
No, you are going to a particular destination repeatedly.
No, repeatedly because I have a business connection, my lord. My company are there.
Maybe you are correct.
Your lordships, your lordships on the
My lord, I have a past travel history. I have a past travel history of 2010, and even during investigation, they have not asked for my passport. I have traveled 2016 to 2023, even after charge sheet. They have never objected, and that is what your lordship has noted in the earlier judgment, which I have annexed in the this petition, my lord. And what the learned trial judge is doing, my lord, is just reproducing the order passed by his predecessor. He is not considering the what his predecessor has done last time while rejecting my application. He has just repeated it.
Okay.
So that is the difficult. Your lordship kindly see.
Let us hear what are the objections.
My lord, last what I did actually, I was supposed to travel in the February month, my lord, because the exhibition was there. I applied in time. In 24th of January, I applied. They put it for office note, all these things, and finally they heard the matter on 7th. Kept the order for reserve for 4 days and thereafter rejected, my lord. My entire things were frustrated.
Yes.
That is the difficulty, my lord.
So then your immediate requirement to go to London for attending that conference.
Conference is over.
Conference is over now.
Conference is, but my lord, since it's the month of March, I have whatever things has been done during that exhibition, my lord, I have to regulate it because I am the CEO of the company. I require, my lord, I will go and with any condition, my lord, because I have already traveled, I have already surrendered my passport.
Okay.
And your lordship.
Let us see.
And my lord has, in the co-accused, your lordship has given this order. So for this case, your lordship has allowed.
These judgments, your lordships had seen it last time. Same thing.
Yes.
Same judgments.
And this.
Okay. I know.
On the last date of hearing, your lordships had asked him a question that why you are frequently traveling to USA and UK only to those places. Kindly answer. And second, your lordships, on the last date of hearing, when my learned senior was arguing the matter, he was in an undue hurry. He said that only 2 days time are required. Then your lordships, he could not mention the matter for 14 days.
No,
The
no.
matter is listed today. That
My
itself
lord,
shows
your
that there is
lordship
no
has
urgency in the matter.
specifically posted the
It's all
matter
right.
to 21st
That
and
itself shows that there is no
court was
urgency.
not
Now,
there.
your
Those
lordships, when
points
this
are needed.
your lordships, this
Yes.
matter was listed on 14th.
Hmm.
When this matter was listed on 14th, your lordships had categorically asked that what is your travel plan? Why do you want to go? Kindly tell something in details because the petition doesn't contain anything. Then your lordships, he filed a supplementary affidavit. Now, if your lordships will kindly come to the supplementary affidavit, page 7,
Yes.
there are some mails he is annexed. That mail, your lordships, is dated 17/2/2025. That means, your lordships, the supplementary affidavit was filed on 18th. This document was manufactured on 17/2/2025 and 18th it was filed. So when on 14th he filed the application, your lordships, this letter was not there. So this supplementary affidavit which is filed in page 7, your lordship may kindly come.
Page 17, huh?
Page 7 of the supplementary affidavit. One Outlook mail he has quoted.
Okay. Okay.
K. Chandrasekhar, mail dated
Yes.
17/2/2025.
Yes.
Now this application was filed on 14/2.
Hmm.
The mail dated is 17/2 and another affidavit filed on 18th. That means, your lordship, when the petition was filed, this document was not there. This document was manufactured on 17th, so that it could be filed on 18th. Number one. Number two, your lordships.
Because they didn't know that you will oppose. So they have not seriously done any, homework.
Number two, your lordships, is paragraph 4, page 2 of the supplementary affidavit.
Para 4, huh?
Yes. That exhibition, your lordships, was from 19th February 2020.
That is over. That he says that is over. Yes.
And this distributor has to be identified from the exhibition only, your lordships. If there is no exhibition, he did not attend, how he will identify the distributors? So it is only for a leisure trip, your lordships. All the requirement, your lordships, if you lordships will see the mail, nothing, his physical presence is not necessary, your lordships. Zoom call, everything
He can see business purpose. He can go in a pleasure trip also. He is not a convict. His right to travel cannot be taken away.
But your lordship, the condition for the trial is that he has to, your lordship, appear. Trial is going to start, your lordship, every month he is going away. That cannot become his habit, your lordship, just because the fundamental right is available.
Trial has not started, my lord. Papers have not been
read what are the
100.
What is the stage of the trial?
Trial, my lord, 1100 documents, 237 witnesses. Not a single, not.
Let us.
I'm appearing in the trial court.
The general statement will not help unless you focus the thing. You won't
I'm
get
appearing in the trial court.
Let us understand what is the stage.
I'll accept your lordships.
No, my lord, the 7th last date was on 7th of February. Next date is on 7th of March. Only is posted. Accused persons are represented through 317. Bas, nothing. Aur kichhi nahi. I'm appearing.
Charge has been framed.
No.
Charge is not.
Charge has been supplied.
Oh.
Police paper has not been here. 1100 document. Your lordship may record my statement.
You have not supplied.
37 witness.
Yes, Mr. Naik, you have not even supplied the copies.
Your lordship, that instruction, your lordship, about the status of the trial.
Let him go for some time and come. What condition you know?
Yes.
You tell me what condition.
I will give my itinerary and I will give my to and fro tickets. Everything I will give.
See, you do one thing. See, your grievance is the trial court has rejected the application, simply reproducing the earlier order. Okay.
Yes.
This is one step. Second is when I asked you, give some document. You have manufactured according to
not manufactured.
Not manufactured.
I have made
1 minute. Those documents were not available with the trial court
on the date of filing.
Because date of filing. I will set aside that and ask you to go to trial court. The trial court apply the mind afresh.
My lord, again, I will be in trouble, my lord. My lord, already it is delayed. My lord, again, the trial court will.
Your application, you moved the application saying that there is an exhibition. That exhibition is gone. And everything is over. Now, fresh cause of action.
With any condition, my lord has already granted that.
Your lordship may kindly come to page 10 for a moment of a supplementary affidavit. Page 10
there is an opposition what to do. Yes, supplementary affidavit.
Page 10 supplementary affidavit. Your lordship asked him to annex documents. That last paragraph.
I'm having my permanent business at Bangalore, my lord. How can I go, my lord?
Yes, 10. Yes.
Mr. Acharya, 1 second.
My lord, already
page 10 supplementary affidavit.
4th of March.
Your lordship, page 10 supplementary affidavit. Lordship may kindly come to the last line. Dear Mohammed. After that, everything is missing, your lordships. Even the communication, your lordships, he has picked and chose, and this communication is also incomplete. Where is the complete mail, your lordship? Dear Mohammed, after that there is nothing. It's coming to the High Court and filing documents. Dear Mohammed, after that the mail is missing, your lordships.
My lord?
Page 10 last.
Yes, I'm there.
Sankar, January is your lordship, February 7 mail. The mail is not there, your lordship. Only the subject is there. Below it is Dear Mohammed.
No, trailing mail is not there.
Not there, your lordships. So you cannot pick. And in any of the mails, there is no requirement to travel, your lordships. Let the matter be remanded back to the lower court, your lordships.
But in any case, since the trial has not yet been commenced,
Your lordship, let the lower court apply the mind.
Let him go. Let him.
Your lordship, these documents.
Yes, madam. I will supply my journey ticket. Everything I will do.
Yes.
Your lordships, as these documents were not perused by the lower court, as your lordship suggested, let it go back to the trial court. He will apply the mind.
That will be delayed the process, my lord.
Oh,
delay the process, my lord. Already I am delayed.
There is no urgency, your lordship, because the exhibition is gone.
Exhibition March मास
So the trial court order.
My lord, that is annexure, my lord. Order dated 12/2/2063, page 63.
Yes. Show me.
63.
Page 63.
Yes.
He has recorded the contention that whatever, then these are the. This was my my plan, my lord, to travel on 17th of February, but it has been frustrated, my lord. Then I cited these judgments, and even the petitioner has also availed this benefit by your lordship's order. That order I have filed. He said that the judgments are not applicable. My lord, even the petitioner's judgment is also not applicable. Your lordship may kindly see. Under such circumstances, I am not inclined. And my lord, another thing, he has quoted the judgment of the Supreme Court that Amanpreet Singh, through which he has dealt as if it is a bail matter.
Your lordship, let the matter be remanded back.
Apart from the fact, the ratio of the judgment cited by the learned counsel
Come
are
to
not.
page 65.
My lord?
Come to page 65.
Yes, madam.
You want to go from 17th February 2025 from Bangalore to London, 17th March 2025 from London to Austin, and 17th April 2025 from Austin to Bangalore.
Yes, that was my initial plan, my lord. But that has not been done. I am unable to do it because my petition was rejected. So only I will go in the month of March to Austin.
The way he's filing application, trial will be in Austin, your lordship, not in India.
Because March month is very important for me, for my business, my lord. Because the entire revenue I have to for the entire year revenue, everything has to be done. But my lord, I know, but this case will continue for years together. 237 witness can be completed.
You give it to me. I'll pass the order, and you give your fresh itinerary.
Yes, I will give.
Yes, your
I will give.
Fresh. Okay.
My lord, one thing, my lord, one observation your lordship may kindly do. My lord, whenever we are filing a petition for this
I can't pass a general order.
Not general order. Let him consider on its own merit, taking into account.
Obviously, that.
But that there,
case
from the gamut of the order your lordship find, he is not going to the contents of the petition. He is considering that merit as if he is dealing with a bail application.
After all, you are facing a serious charge, not that you are.
But he should also give his your lordship's.
You can't have both.
Your lordships.
Face the charge and.
That is that's
keep on going.
I should have been in custody, my lord.
Your lordship live WhatsApp location also should be given your lordship if your lordship is allowing.
Yes, everything live location, everything I will
your
give.
lordship, the way he's traveling abroad, I think the trial will be in USA.
Everything I will give.
How Odisha trial?
I am not going away.
Let him give.
My money is also secure, my lord. They have freezed my money. That amount which is involved in this case, that is also with them.
Already seized.
6 crores rupees.
It's the border company apuni proceeds of the crime.
Okay, you give itinerary.
My lord, itinerary I will file before the trial court.
Yes.
Yes, I will produce.
Your
lordship direct
application.
I will produce my itinerary.
Give me, I'll pass.
Travel
Yes, I'll pass the order. Yes.
But my lord, the order may be given tomorrow.
Let me see if I will get up, then only I'll do it.
And also the order should be uploaded, your
Because
lordship.
I have to, after your lordship's order, I will book the ticket because once I have booked and cancelled it.
Your lordship, the order should be uploaded so that I can.
Let us see the depth of this.
Item 8586, Mr. Anirudh sir is appearing and he said that the interim order first earlier may be continued. But there is no interim order in that.
If interim order is there, then
85 and 86.
no interim order.
No, my lordship.
88.
Yes. Settled. Not settled.
Settled ହେଇପାରିବନି.
ହେଇପାରିବନି.
My lord, settled ହେଇପାରିବନି because there is a one legal question is involved that whether a student can claim this insurance or not. He is claiming that he is a helper, but actually he is a student. So
what is the claim?
Claim is 14 lakhs. The awarded amount is 14 lakhs by the trial court, but trial court has failed to understand that he is a student and insurance company is not liable to pay him third party. It doesn't fall within the third party compass, my lord.
If he is working and pursuing his
No, my lord. The deposition doesn't relate to that. He is only he's saying that helper. Sometimes he's saying that I don't have any papers.
There are many poor students. They are working as well as pursuing their study.
My lord, interestingly, and second point that my lord I want to canvass. He is the son of that owner of the truck. Okay. He is the son of the there is no employer or employee relationship. So the amount under employees compensation, my lord, is also not.
What do you say?
It is with regard to the first allegation, my lord, their manager, the employer manager of the opposite part number 1.
Helper claim.
Manager examined. Page 4 running by the 11th point, page 4 of the judgment. The last paragraph, he has stated that he was the respondent, the claimant is working as a helper.
LCR has to be called. LCR has to be called.
Insurance.
It is to be argued, then LCR has to be called. Huh? No, LCR is not there. Evidence has to be read.
As soon as chatta bajlan, as soon.
LCR I'll call for the LCR.
My lord, I call for
this. Call for the LCR.
I'll set up.
Please the matter for this.
Yes. I'll set up.
I just, if possibly, if you settling the dispute,
yes,
it's all right. If not, then we'll let you get.
Maybe the
let the LCR come.
LCR as to my lord is fixing date.
Otherwise, also, Mr. Patnaik is now busy. We will not argue now.
My lord, sorry, my lord.
You are now busy.
Yes, my lord.
So you will not argue now. That way at 4 o'clock.
My lord, a lot of stress. Lot of stress, my lord. That's the whole
So
problem.
therefore you shouldn't argue.
Yes, my lord.
Yes.
Only that my lord, April they need it.
Yes.
89.
My lord, 89. Here, claimants have filed FAO 269 of 24. And I, as insurance company, has filed FAO 305 of 24.
Yes. Yes.
They have.
You are taking arrangement.
They have filed. No, I am for the insurance company.
They have filed.
They have filed claiming interest. Interest on the awarded amount. I have filed challenging the quantum.
I'll dismiss both.
No, my lords. That can be disposed of. The matter we have already settled.
Otherwise, both the matters is dismissed. Then you also own, he also own. Yes.
Sir, take correction. Addition.
You are talking about 305.
Yes, 305 is Oriental Insurance appellant.
And what in the light of this order, the other one can be
both the appeals can be 17,60,000 has been consolidated.
17,16,000. Both the 305 record and 296 in the light of.
So there are interest someone claim for
in FAO number 305 of 2024. The disposal. The appeal is disposal.
No, my lord, we have already deposited the awarded amount before the court below. এটা যেহেতু বড়ি যাଉଛି অ্যামাউন্টটা 17,60,000 হচ্ছে, will deposit 17,60,000 and take refund of the amount with along with accrued interest, যেটা আমি অলরেডি জমা করি। এটা লিখিছো সে সাইড রে সে পেন রে লিখিছো। ওকে, যেহেতু ইন্টারেস্ট আড হলা অ্যামাউন্টটা বড়িগলা 14,41,050 we have already deposited.
अच्छा,
That will take refund along with accrued interest.
ठीक है, फुल स्टॉप कर दी, फुल स्टॉप कर दियो, एंड कर, फुल स्टॉप कर दियो, the deposited amount na, the award amount which has already been deposited by the insurance company before why
My lord, before the employees compensation, Khurda, Commissioner for
compensation
Khurda, in EC case number 07 of 2020
shall be disbursed to, shall be returned to the insurance company
along with accrued interest,
along with the interest accrued thereon. Accrued the e% of cut, e% of cut, e% की जगह सीधा लिख दो और ऊपर से ठीक है। 90 रह गया क्या भैया, एक ही और कितना रह गया लास्ट yes
appeal against an order making interim attachment fine to take a lot of take some time.
In fact,
I'll call for the record then.
My submission, my lord, in the third tag case, that can be disposed of. In fact, I am challenging the portion of the order where it has been stated that 32% belongs to me. I have been of that entire property which is under attachment, and 68% to be sold off. My proposal is that let the entire property be sold off and I'll buy it. I'll pay to the distributor, the depositors. So there is no need for any auction. And even if your lordship holds for an auction, then I'll participate in that to given within a time frame. That is separate. No, that is
My property is go away connected because it should not.
no. My case is separated, separable from my learned senior's case. It is for a different project altogether, and my case is for a different project by the same promoter.
Is there any chance of settlement if you send it to?
There's no question of settlement here.
No.
Here, my lord. My property.
अच्छा attachment हो
And probably I was not clear, my lord. What has happened here?
I can't segregate unless I hear it.
No, the projects are different. Land is different. His property is on a separate land.
If they agree to that, then I will separate it.
There should not be any impediment to there.
I am on BC Miller.
ହଁ କିଛି ଅସୁବିଧା ନାହିଁ। ମୋର ଅଛି ବାଲେଶ୍ୱର ଅମୁକ ଏରିଆରେ ସେ ଡ୍ୟୁକ୍ କରିଛି, ତ ମୋର ଲ୍ୟାଣ୍ଡଟା ସେଇଠି ଫସିକି ରହିଛି, ମୁଁ କିଣିଦେବି ପୁରାଟା। ତାଙ୍କର ଲ୍ୟାଣ୍ଡଟା ବାଲେଶ୍ୱର ଆଉ ଗୋଟେ ଏରିଆରେ, ତ ତାଙ୍କର ଶୁଣାଣି ହଉ, ସେମାନେ ରିଲିଜ ପାଇଁ
I'll detag it and hear it separately.
ଯଦି short date ରେ କରିଦେଲେ this will be.
I'll detag his matter here separately, so appropriate order can be passed.
I am on BC Miller. Am I audible, Miller?
Yes, sir. Yes, sir.
Miller, now my learned friend, Mr. Rath says that he is not agreed with the order. Let him withdraw the appeal.
No, we agreed with it. That is not the essence of my argument.
You are happy with the order.
No, I am not aggrieved. I am saying I am challenging that portion of the order where it has not been released in my favor. But to save time, and to benefit the OPID person, it is not.
He want to sell it. The entire.
I want to buy.
Sorry, buy.
Whatever the valuation is.
Millard,
I'll buy it.
Can part of the order will be confirmed and other part remain to be tested as whether it is correct or not?
That is also mandate of section 9(6). That is nothing new I am submitting out of the statute. It is there in 9(6).
Detag it and hear it separately.
My lord, grateful.
There is no problem, Millard. Once your lordship
hears, confirms the order in his appeal, Miller, can it open for challenge in other appeal?
No, this, see, the third, Mr. Rath's matter is completely different property, completely different.
Yes.
thing.
Miller,
The
it is arising out of the same judgment. If my Lord and Friend
All the
agrees
orders are
that
different,
he
the
is
observations are
appealing
different.
the-
Though it is passed in one
Common
order, but observation and
common order,
relating to
Miller.
all properties is
Whatever
different.
observation your lordship will observe as per the submission of my friend, that will affect me. That's why
Then,
He is the builder.
that will affect me. I am the builder. I suggest one thing. Since the interim attachment has been become final, ultimately the property to put under auction.
How can it
Yeah.
be put unless my appeal is heard and
No.
rejected?
So it is just
that is his submission.
it is just
How can it be such a
it is just statutory appeal.
It's a statutory appeal.
Yes.
It has to be heard and decided. Thereafter, the other rest things will come.
So my suggestion is very limited. My friend misunderstood me, that's why he intervened. It is a statutory appeal and the appeal is to be disposed of. Till then, I suggest that I filed a petition in the midst of the proceeding on section 11 of the OPID Act. That provides that if the affected party intend to deposit the amount which has been gathered during course of investigation, then the court may pass order and release the property, keeping the money.
Yes.
I filed the petition on section 11 of the OPID Act, but unfortunately the court did not dispose of that petition and passed the final order. So I suggest before this honorable court, keeping the interest of every stakeholder, not mine
There is
alone,
an application be
I will deposit that amount and the order of the confiscation, absolute order which has been absolute, that becomes stayed till the final list. That will meet, that will
Miller,
keep the interest of everybody, every stakeholder.
Miller,
Yes,
at the outset, your lordship may kindly see section 11 has been taken away from the statute. My lord senior may examine section 11 is no more there in the statute. It has been amended in 2019. Either my lord senior is holding the book which is obsolete, or he has not gone through the latest amendment, Miller. Section 11 is no more there.
It is repeat that part of the provision.
I am holding in 2024 book where it is there.
He says
Yes, my-
Subject to verification what my friends.
he says one thing.
Anyway, my lord.
One thing.
11 is
No longer there, but whatever maybe, my lord, my simple prayer is that let my matter be detagged, and your lordship will find that I have
No,
a.
no, DTAG will be problematic because he has an objection to that and it has a bearing. Without hearing him, I can't. Let it come. Call for the.
Your lordship.
I will call for the record, trial court record, and release the matter on Kabhi Kar Do Batao, and on 21st.
Your lordship.
28. On
May
28.
I say one thing, my lord?
Yes.
Till then, at least, the order of, passed by the designated could be stayed. Otherwise, they may take action. So your lordship, till then.
Once there is an appeal, it is has to be stayed because
That
everything, the order of the trial court is to be.
Yes, Mr. Bhuya, what do you
Miller.
say? It should be stayed ideally.
Yes, appeal is the ultimate appeal.
Impugn order,
That is
operation of the
statutory
impugn order is state. Operation of the impugn order is state. Yes.
In connection with this matter, another matter is there. I am giving the number, your lordship may.
Least that matter. Least that matter along with the 28th of this.
I pray with the observation on that day, endeavor to complete it. That observation maybe. Eventuality. Conscious,
Your lordship
at
may
least.
call for the LCR also.
Least the matter on 28th, call for the trial court record, impugn order is state, and it's made clear that on that day, the matter is shall be heard finally.
instead of 28.
First week of April would be better. 29th is election day.
Are you contesting in the?
I may not contest, but I can ask for somebody.
No, if the matter is urgent, he'll take recall. Let it be urgent first. Then fourth.
Then second.
Thank you.